Your Lords, with your Lords of kind permission, 2 matters for admission next week, fresh matters.
We'll see. Yes, out of the list.
Ladyship, there was a matter fixed for chambers at 5 o'clock
Today it's not possible, that's why it's kept to Monday.
It's for Monday now, Ladyship. And Ladyship, there's another writ for striking of, it can be listed along with the same writ.
Along with the chamber
Subject to
matter,
clearance of objections, it can be.
which is supposed to be listed today, along with it. One chamber matter was there today.
I'm so grateful.
Yes, call the list.
Monday at 5 p.m., Ladyship? Monday also at 5 p.m.? Grateful.
Not fun. Beloved.
Your Lordship, the Learned Family Court had granted only 6,000 as maintenance, whereas the petitioner is surviving with 2 twin children. And the
Correct. Again, which year is the writ petition?
25, Your Lordship.
When did you file?
March, Your Lordship.
It will come. Give the memo to the court officer. Yes.
List one serial 3, I seek withdrawal.
This one, serial number? Switch on the
In
AC
matter
for
before
some
trial court had been closed.
time. AC for some time.
Page wise correct.
A memo is filed stating that the main petition itself is disposed of, hence nothing survives to cover consideration in this petition, and accordingly, the memo is taken on record and dismissed as withdrawn. Yes.
Page wise assignment, list number 1, page number 2, page number 5 to 7, page number 3, 8 to 11, page number 4, page number 4, 5 to 14.
That's serial number 13, my lord. I am for the petition in this case, madam. We are going to settle the matter, my lord. Kindly have this on a week after next.
Appears for the respondent.
I am for the respondent, Lord. The settlement talks is on, my Lord.
It is submitted to the settlement officer going on.
Kindly have this on 19th.
Matter on 21st.
Obliged.
Much obliged.
Serial number 14, my lord, kindly
Yes.
written next week, my lord. And for the respondent,
Have you informed the petitioner?
no, my lord. I'll inform, my lord.
No. Please wait. When the matter is called, then you can ask for adjournment.
Please.
Yes.
Serial number 17, my lord. For the respondent, we are supposed to file our objections. I had recently come on record. I have not received the trial court records.
Have you informed the petitioner counsel?
I don't, I'll.
Please wait.
Yes,
When they come, you can ask for that.
Yes, ma'am.
Yes.
Serial number 16, my lord. Connected matter between the same parties is listed on the 19th. This is under section 24 of the Hindu Marriage Act. 125 proceeding is listed on the 19th before your lordship.
Both can be clubbed, so no objection.
On the 19th.
It's coming up on 19th.
19th, dates given.
Oh, connected matter to, I was thinking 16 and 19.
Sorry,
List along with, give the number,
RP.
along with so and so on 19th.
Pledged.
Your Lordship, if counsel's wakalat could be reflected, Your Lordship, that's not coming up.
For the respondent, learned counsel, Mr. Gautam Raghunath submits that he has already filed the wakalat. Registry is directed to fit the name of the counsel. Yes.
The interim order.
Interim order earlier granted is
Right.
extended till then. Yes, next.
Obliged.
Lords, serial number 24, appearing for the petitioner, my lords. Parties are almost settling, my lords. Only the documentation is left, so 2 weeks' time may be given, my
Your
lords.
lordship, an anti-suit injunction, my lord, where the husband had filed in the US.
Yes.
We have settled the matter, my lord. We are in the course of preparing the mediation settlement agreement.
When do you want?
Any date after 20th, my lords.
List the matter on 22nd.
Grateful.
It is submitted that the parties of, or the matter is going to be settled between the parties. Yes.
Obliged.
I think they are not here. Oh, I'm told you have informed the,
Yes, Lordship, we've inquired, they're saying it is closed. Can it happen in Lal Bagh or something like that?
Mad, senior counsel.
My lord, I was involved in the family court development when Justice Navaratna was there, my lord. Especially the room was earmarked. Fourth floor, it is there for conciliation. All that the court was, Gopalappa is the director, my lord. He said, if the court orders, we'll keep it open.
If the court orders it, okay, Lordship. Or else we are just requested Lal Bagh that. Oblige.
It is submitted with the senior counsel that she has inquired with the mediation center, with the director. If there is an order by the court for visitation, the visit, though, even if it is a holiday, the visitation will be kept open. Yes.
Oblige, oblige, Lordship.
Serial number, list number 1 for preliminary hearing, serial number 1.
For the petition,
Endoli,
in this, per the petitioner, the petition.
About the jurisdiction issue,
Yes, my lord.
let's see the order.
Page number 49, my lord. Relevant portion. Para number 12, my lord. 13. Both the parties acknowledge that the child resides in Davanagere, prompting a question of regarding the jurisdiction of this court. It is settled law that application seeking custody of a minor child must be filed only the court where the child ordinarily resides. Section 9 permits such application to be filed in the court with jurisdiction over the child's residence. The law stipulates that the guardianship applications must be presented in the court where the child lives, as only that court possesses the necessary jurisdiction.
No, GNWC is filed in the year 24.
Please,
That was numbered.
pardon,
It was numbered.
numbered.
There was no objection with regard, no, then, after that, wife has filed any application
No, my
to
lord,
reject
they-
the plaint, to reject the petition?
No, my lord, no.
Court
They-
has simply said so.
Simply, they have filed the objection to the petition.
Hmm.
They have taken condition that they have shifted to Davangere. Now the child also studying it.
So, where are those objections?
Please, madam,
Page number?
please.
Switch off. Yes.
Page number 37, my lord. Para number 9. Translated governments. The respondent further states that above a year ago, due to the petitioner's severe physical and mental cruelty, the respondent left the petitioner's house with a minor child, enrolled the child in a good school in Davangere.
She later went to the applicant's house. Where is your house in Shimoga?
Please, I'm in Shimoga.
Hmm.
Her petition for divorce is pending before the Shimoga. Still they are contesting the matter in Shimoga.
So from the last 1 year, the boy is at Davangere.
With her. 1.5 years.
Then
My contention is that, my lord, the petition, divorce petition pending before the Shimoga. Hence, this court also.
No. As far as the matrimonial dispute is a different aspect and custody is a different aspect. As for section 9 of the Guardianship and Wards Act says, where the minor ordinarily resides. So, because of the disputes between the parties, they moved there. And from the last 1.5 years, he is residing there. He is studying in the school. And mother has the intention to keep him in the same school. So, under section 9, it is a court at Davangere which has jurisdiction. Please come. Agreed with the orders passed in I number 1 in GNWC number 14 of 2024 dated 25th April 2025, whereby the court had dismissed the court had passed an order rejecting IA number 1 filed by the father seeking visitation rights for lack of territorial jurisdiction. As the child is studying in Davangere, the petition under section 7, 10 and 25 of the Guardians and Wards Act seeking custody of the child is returned with the direction to present it before the court where the child is residing. Learn counsel for the petitioner further submits that the parties were residing in Shimoga the wife had given a complaint in Shimoga, and also he has filed a petition for restitution.
No, my lord, divorce.
You only filed.
No, my lord.
She filed.
She paid
And
divorce
the
petition.
mother has filed a petition seeking divorce against the father in the court at Shimoga. Hence he has come up, he has filed the GNWC 14 of 2024 before the family court at Shimoga, seeking custody, and filed a visitation, an application for visitation that came to be dismissed on the ground that boy is residing at Davangere. Land counsel appearing for the petitioner submits that the courts at Shimoga also having jurisdiction, as both the parties were residing in Shimoga, and also the mother has filed a MC for divorce, which is pending on the file of the family courts at Shimoga. Hence it is submitted that the court, without considering all these factors, had held that the court at Shimoga has no jurisdiction, and it has to be presented before the court at Davangere, where the boy is residing. Next paragraph. Having heard the counsel for the petitioner, peruse the material on record. Filing a case at Shimoga seeking divorce or any other criminal complaint altogether stands on a different footing, where the petitions are filed under the Hindu Marriage Act. And when a petition has to be filed under the provisions of the Guardianship and Wards Act, Section 9 of the Guardianship and Wards Act is very clear that the court in whose jurisdiction the minor ordinarily resides will have the jurisdiction. In this case, after the disputes, the wife is residing in Davangere from the last 1.5 years, and the boy is also studying at Davangere. Hence, for all practical purposes, the ordinary place of residence of the boy is Davangere, but not Shimoga, and the court had rightly passed the order, and this court finds no reasons to interfere. Accordingly dismissed. Next.
Cell number 2 for dismissal, Ankraj K for appellant.
Why Mr. Shantras is not well?
Oh, Mahesh sir.
I appear for the respondent.
Even on the last occasion also there is no representation, several occasions. Is he coming to the court?
He's coming, my lord, but MFA 370 of 2019 filed by the Tata AG was allowed on 10/12/23. In view of that, my lord, the present appeal does not survive.
What is the number?
MFA number, sir.
370 of 2019.
Dated?
10/12/23.
Take that order.
Yes, sir.
Password.
Cell number 3 is closed. Cell number 4. Cell number 4.
For the petitioner, both the parties are residing together, my lord. We'll report a settlement after 2 weeks, my lord. Other matters also there, criminal matters. We'll report the settlement 2 weeks, my lord.
Why there was no representation on the last occasion?
Last occasion, my lord, I informed the other side. He said, my lord, he will appear, but unfortunately, he not appeared. Before the coordinate bench, my lord, both the parties present, my lord, they admitted that they are together.
There is no representation on 13/6.
Please, my lord.
There is no representation on 23/7.
Please, sorry, my lord.
No, you just can't take things so casually. There's this matter on 21st for reporting settlement, or else the council shall argue the matter on the merits of it. Listed, delete from the caption dismissal. Yes, next.
Cell number 5 for others matter. Cell number 5.
As per the postal
very
notice to R1.
One submission.
Returned as unclaimed. Amounts
unclaimed,
to deemed
very all 5 respondents filed MFA number 4559 of 22 by Vinod Gowda advocate. Kindly put up the appeal.
What is the number?
4559 of 22.
Post along with so and so next week.
One submission, please. In this case, I'm permitted to take serve the copy on the respond number 8 on the advocate before the tribunal. He is avoiding the.
So you're saying that 8 is there as a party in the other petition.
He's not there.
Then who else?
He's also there.
Then you can serve that advocate when it comes.
Apart from submission, respond number 3 has been deleted before the trial court. Again, here also deleted. He is a necessary party. Filed an implementing application to this respond number 6, please. In my appeal. Kindly issue notice to the respond number 6, please.
I have 1 of 25 notice. Anyhow, let no notice, let the other matter come up.
Please.
So everybody is there before the court. List along with that next week
Yes, ma'am.
on Thursday. Yes, nice.
49. Serial number 6.
Appear for petition, ma'am.
Where is the respondent?
Kindly peruse the order. Kindly peruse the order dated 26/7/2025, ma'am.
Have you received the objections?
No, my lord.
Please argue, we will decide.
Yes, ma'am. There is an order dated 26/7/2025. There is a clear direction to the respondent to bring the child to the mediation report to complete the order passed by the trial court. Even there
where is the impugned order?
Page number 93, operative portion, 110, my lord, 119. Operative portion of the order.
119,
my lord. 18 and 19. Starting from 27, there are 93 pages order on IA. IA number 3 filed by the respondent under section 157 of CPC is hereby allowed. The petition is directed to pay a sum of rupees 3,37,540 in respect of school fees of the children as sought by the respondent in IA number 3. IA number 4 filed by the respondent under section 24 of Hindu Marriage Act is hereby allowed. The petition is directed to pay a sum of rupees 10,000 each per month to the respondent and 2 children, Kumari Aishwarya and Master Atharvan Nalige. In total 30,000 per month from the date of IA number 4 from 22/1/2021 till the disposal of the case. The petition is also directed to pay a sum of rupees 50,000 to the respondent towards the litigation expenses. IA number.
What happened with this order to produce the child? What happened?
They are not bring the child because they send the message that the children is not intended to see the father and also they are suffering with some health issues. Even from
any stay?
No stay, my lord.
The Land Counsel for the Petitions of this Act, in spite of an order passed by the court, where the court had directed the father to pay the maintenance and directed the mother to permit the father to have the visitation. Right from the day of the order till now, the mother has not produced the children. Even before this court also, there is no representation on behalf of the respondent. They shall be stay as far as the payment of maintenance, the payment of school fees is concerned. School fees and maintenance is concerned. Yes, this is matter on 10th of September.
Macho.
Yes.
Number 7 for hearing on interlocutory application 7. Raja Subramanya Bhatt.
Appeal for enhancement.
For
This
R3
copy is
Lordship.
to be served on him. I will serve a copy on the
Please receive a copy, my
BBMP.
lordship. I am for R3, my lordship.
Once one Mr. Nagaraj appeared and took time.
For R3 only.
Okay, I afresh I will serve copy
One
on.
minute. The Liberty Videocon General Insurance Company. You appear for the respondent insurance company.
R3, my lordship.
R3.
BBMP.
Huh?
BBMP R3, my lordship. only.
R3.
R3. my-
Commissioner BBMP.
Yes, my
Yes.
lordship.
Then what about 2? 2 and 1?
Once Videocon fabricated, that is notice is not.
Notice to
ordered.
be ordered in respect of R1. Notice is not ordered till now.
Yes.
Yes, my lordship. First one case I undertake to file wakalat. my
Kindly,
lordship, R3.
kindly the order for
Notice
issuance
to
of
respondents.
notice.
1 and 2, and Mr. So-and-so undertakes to file wakalat on behalf of respondent number 3, and the counsel for the applicant should serve the copy of the
Yes.
appeal memo on the counsel for the respondent. Then 7.1,
That is connected by appeal by
then he must be appearing the claim.
perhaps.
Already filed wakalat, my lordship. Second matter already filed wakalat, my lord.
Mr. Mahesh,
Yes, my lord.
in 7, you appear for the insurance company, respondent number 2.
Yes,
Respondent number 2.
that is
7760 of 2019 is by me.
Correct.
yes.
Then in MFA 1881 of 2022,
No, there is no notice ordered, my lord. I have not received the
Mr.
copy. I have not-
So-and-so.
I undertake to file
Mr.
serve
O.
notice
Mahesh,
on Mr.
who's
Mahesh.
appearing on behalf of the insurance company in the connected appeal, is directed to take notice, and the counsel shall serve the
Yes.
copy of the appeal memo, and only notice
Notice
is to
was
the
not
first
ordered.
respondent.
First respondent.
First respondent notice. Yes, next. Next date, list after service of notice. Yes, 8,
Serial number 8.
notice. Other side is appearing.
Appear for respondent.
Each NR
Only one
is
respondent.
Connected petition is also there, my.
What is the
filed by
number?
RPFC 219 of 2025.
Post along with that on 20th.
Please, my lord.
Yes, next.
serial number
9.
9.
Oh.
Number ಬರ್ಕೊಡಿ sir. Serial number 9.
It's appear for petitioner minutes. Notice was issued to respondent. There's some representation.
Respondent.
Respondent.
So objections need to be filed. He's appearing, entering appearance for the first time.
Not what objections, we look at the order and he has come to the impugned order, very simple.
Yes. Annexure A, page 20 is the order. 20 minutes. It is against enhancement of compensation laws. The petitioner wife had filed application seeking maintenance of 25,000 each for her and her son minutes. Totally 50,000.
Court had granted 5,000.
5,000 only for the child, rejecting any maintenance for the wife minutes.
Why?
On the ground minutes that wife is earning and that at that particular point of time her
How
salary.
much is earning?
Lots, as per the records, lots, court has held from the bank entries for 43,000 rupees and about 43,000 in 2019 and about 48,000 odd in 2020.
And what about the husband's income?
Husband's salary, only 2 months salary was reflected, 34,550, 540 minutes.
What is the age of the child?
Lots, at the time of filing the petition, he was 4. Now, lots, he's subject to continue 7 or 8-year-old child. Lots.
Yes.
My lord. Petitioner, according to petitioner, assets and liability. She is studying, she is getting salary of 1,50,000 rupees. She is MNC company, she is working in MNC company.
So she says 48, 43, 48,000, uses 12 lakh.
Oh, my lord. Assets and liability, I have also point, the petitioner counsel also filed, my lord. It is clearly indicate that she is getting 1,50,000 rupees more.
No,
See,
assets and
he is-
liabilities.
my lord.
This
My lord,
recorded
he is-
para 10 of the
he is
impugned
studying-
order, page 27.
The respondent is studying only PUC. She is studying in the MNC company and my lord, very, it is clearly this, my lord.
And the court records in the order that it
Court
is 43,000.
is-
How can it be 12 lakhs? Where from you
My lord.
get it?
My lord, subsequently, after filing of the interim application, I have voluntarily have filed memo, my lord. Kindly see page number 140. I voluntarily have agreed that I am paying the 5,000 rupees to my child. And kindly see, my lord. Page number 140. Respondent has agreed to pay maintenance of 5,000 rupees per month to his.
That is your memo. Your memo cannot be considered. There should be evidence on record.
My lord, I am voluntarily, I am submitting that I have paying the 5,000 rupees to the my son, along with, my lord, kindly say along with,
condition to give the visitation right. Even till today, they are not sure my child. My lord, kindly see, she is getting 1,15,000 rupees and also the applying
Ready to pay all his educational expenses.
whatever amount, my
Not
lord,
lords.
is spent.
In fact,
I will-
lords, may I just complete? Lords, what is ordered is only 5,000 rupees, lords. MC petition is filed by him in the year 2021. Till date, lords, not once has he uttered that he will take care of the child. In fact, lords, cross-examination.
140, you only file the paper.
Yeah, he is filed memo, lords, but what happens is, lords, after 5 years of pendency of MC petition, when I put him in the cross-examination questions as to which grade the child is studying in, he does not know anything, lords. After that, he comes and files an application now saying that I will take care of the child. Though he admits here, but never, my lords, even in the impugned order also, it's not reflected, my lords. There's no,
1,000 also is not paying.
no, my lords, he's not paying.
No, I am ready, but
Not ready. You should
No,
have
my
done
lord,
it by this time.
they are not giving the any account number and anything. If any
an
account
order-
number, I will pay whatever amount
order was
is
passed
spend the
and
amount.
it's Criminal C miscellaneous 625/2017 dated 16th October 2023, whereby the court had granted 5,000 as interim maintenance. Then counsel for the respondent husband submits that he has already filed a memo for the court that he is ready to pay the entire amount and also is
And
ready to
education amount, education, entire
pay. Recording
education.
that, I'm recording
Please,
that,
please,
he paid. And also ready to bear the entire educational expenses.
Yes, yes, yes.
According to the land council, the details of the bank details are not furnished to him. As such, he could not transfer the amount. List this matter on 28th
In
of
the
August.
meanwhile, my lord,
By that time,
visitation rights.
by that time,
How was that concerned in this petition?
by that time, the entire amount, entire arrears at 5,000 shall be transferred to the wife and
The
he shall
account
file a
number.
memo to that effect. Further, the wife, by today, the wife shall
Let's
give the particulars.
Bank
of the-
details are at page number 107. Bank details are
The
there.
bank details are already there at page number 107. To that bank account, the husband shall transfer the amount. And with regard to the visitation and other things, once the amount is transferred, the court will consider the same.
My lord,
Lords, if there is change in
visitation
account, I will submit,
Once
lords.
in
In case,
month-
I'll just check with the partner.
Very simple. Once in month, if visitation.
The scope
right-
of this petition is not that. Scope of this
Sir,
petition
you
only
also have a
maintenance.
responsibility.
No,
to
we
do
have, lords. That application is pending before the trial court. We have argued it's posted for orders on 2/9.
After 3.5 year, even till today,
1st of September,
the
yes.
petitioner.
Next matter.
It's may I request is to be had on 5th of September.
First, 5th of
It's
September.
because
This is a holiday,
it's, subsequent to that, lords.
9th of September.
Yes,
Visitation
grateful.
rights, my lord.
Interim order to be
Humble
extended.
request, visitation right at least once in 1 month.
You asked something in their petition without even filing a petition.
In trial court, I have filed application.
Let
The
it be-
petitioner
let it-
counsel
Posted
has
for orders, it's
strongly
posted for
filed
orders.
Objection, my lord.
At least I cannot understand and hear what both the counsels
I
are
understand.
saying. Repeatedly, the court is saying that at one time I request advocates to argue, but you always, advocates are always testing the patience of the court.
I apologize, lords.
Yes,
10.
It's interim
Sachin
order to
PS.
be extended.
yes, interim order earlier granted is extended.
Great.
CS Sachin, Ashok Kumar Shetty ke. for
What
respondent.
interim order in this? Why should
the
proceedings
proceedings
of
of 125 because the
proceedings
whole case is
equal
for
to
maintenance.
stay, my lord.
lords. That's why.
My lord, kindly see, further proceedings, it is not required.
Yes, next.
Then number 10.
Lords,
Sachin BS.
I appear for the petitioner challenging the interim order of maintenance passed in the trial court, my lords. In the previous date of hearing, my lords are directed to furnish the details of the arrears, which is passed in DV Acts and also in the 125 proceedings, my lords, producing the memo along with the assets and liabilities, my lords. Lords, the petitioner is, my lords, is working as a vegetable vendor. Now he is
Granted interim order on the ground that already an amount of rupees 7,000 is granted. Appearing to the respondents of the petition, either he is paying maintenance of DV Act, it is coming up for this court and somebody that there is an order. Then counsel for the petition instruction, when is the order passed in the DV case? And how much is the amount paid till now?
please, my
How
lords.
much you have paid till now?
My lords, in the 125 proceedings, my lords, I am paying rupees 2,000 per month, my lords. But in DV Act, my lords, I have not paid.
Then why was it submitted before the court as if you are being made to pay 2 times?
No, my lords. The reason is this, my lords. I'm a vegetable vendor, my lords.
Reasons are not, I'm not concerned with the reasons. I'm only concerned with the submission. So let's go to the order that is passed. What is the submission that's made?
No, my lords, there was no such submissions were made, my lords. Only the submission was that, my lords, in the DV Act, my lords.
The land counsel of the petitioner husband submits that the husband is a vegetable vendor. And
Please,
in
my
fact, the wife had filed a domestic violence case wherein the court had already granted maintenance of an amount of rupees 7,000. What does it mean?
Please,
To
my
the
lords.
wife. The family court, without looking at the statement, so and so is not so and so. So, because you are already granted an amount of rupees 7,000 in the DV
Please,
proceeding, this
please.
court had granted this.
Please, my lords.
So how can you know neither you pay here nor you pay there?
Please, my lords. FAW was issued. I paid already 5,000. Today I am paying 50,000 there, my lords. The reason is this, my lords. I don't have any, my lords, money, my lords. That is the reason. I am a vegetable vendor, my
If your
lords.
statement is that,
Please,
then all this should have not come. But unfortunately, you said something which is irrelevant.
Oh, my lords. Apology, my lords. With that regard, my lords. But the my lords.
Week's time may be granted, ma'am. Senior is out of station.
This is matter on 18th of September. Yes, next.
My lords, interim order.
Interim order earlier granted is extended till then.
Obliged, my lords.
What memo? Yes, next.
Serial number 11, Champaraju.
Hearing for the petitioners, my lords. But on the last date of hearing, my lords has directed respondent to file an affidavit, my lords.
My lords, last date of hearing, court had directed the matter to post it on 12th.
Petition is having turnover of about 2 crores. He has suppressed several facts and filed a statement. So respondent shall state all these facts in the form of an affidavit so that the petitioner get an opportunity to respond to the same.
My lords, we'll file the affidavit on the next
Why?
day.
It was asked, that's why the matter is listed.
Yes,
Why
my-
are we listing the matter now?
My lords,
Interim order is there.
No interim order, my lords.
No, we'll grant interim order then.
no, my lords, the last date of hearing, court had told that it will be listed on 12/8. We are of the idea that it will be listed on 12/8.
Oh,
That's why.
if whatever is said in the court, that will only be there.
Yes,
in
my
order.
lords. Yes, my
If
lords.
your understanding is different, Abhi, that's not court's problem. You will at least find from the website when the matter is coming.
Apologies, my lord. Kindly have this matter on 12th itself, my lords. We'll file the affidavit.
What is this? You're seeking enhancement of the maintenance?
No, my lords, I sought for reduction, my lords. Impugned order is 25,000, my lords. I'm ready to pay 12,000 per month, my lord.
Come to the order.
Page 75, my lords, impugned order. 25,000 is ordered to respondent number 2, my lords. My lords, my income is 50.
No, I'm not able to understand why he should file the affidavit. Read it. Instead of saying husband shall state, he said only respondent. You are for the husband.
Please, my lord.
Then why will he file affidavit?
Last date he made vile allegations.
The land counsel for the respondent submits that the petitioner husband is having turnover of about 2 crores per annum.
Please.
He has suppressed several facts and filed the statement of others and liabilities, and same is denied by the land counsel for the petitioner. Instead of saying petitioner, it is stated respondent.
No, he made the allegations that I have suppressed facts.
My lords, my senior had made a submission stating that 2 crores has been like his turnover is 2 crores.
The affidavit shall be filed by
12/8.
11th of September. List this matter on 6th of September, 16th of September.
But short date may be given, my lords. There is no interim order. That's
Yes, next.
Serial number 12. Serial number 12. For admission.
Respondent in this case.
Petitioner in this matter.
Ex-parte order, my lords,
Umesh VN.
may be remanded.
This matter is waiting for this purpose from 2021. Where is the order?
Page number
16, 22, my lords.
In
It's
Kannada.
please.
What is the amount granted?
Totally 26,000, my lords.
To the wife?
10,000 for the wife, 8,000 each for the children. Respondent number 2 and 3.
8,000 each.
Please, me.
That is 16 plus 10, 26.
10, 26.
Agreed with the order passed in.
At para 2 of the petition. Criminal Miss FC.
By the orders passed in criminal miscellaneous number 57 of 2020, dated 16/8/2021, whereby the court had granted an amount of rupees 10,000 to the wife and 8,000 each to the children, altogether 26,000. The husband is before this court. And counsel appearing with the husband submits that it is an ex-parte order. Why you have not contested?
The petitioner is a teacher. He engaged in the COVID program.
Submitted that this order is passed during the COVID period. In view of the pandemic, the petitioner could not appear before the court. Hence, the matter may be remanded to the trial court. Some amount you have to pay pending disposal of. From 21, you are enjoying this.
The respondents are having income.
What about the children? Who will maintain the children?
So having their own school and land also there.
Whatever it is, husband has a responsibility.
Already we paid some for respondent number 1. He paid some money. 5,42,000.
What is your income?
Income 1,05,000.
Huh?
1,05,000.
1,05,000
Yes.
is your income. What is the age of the children?
Now 21, they are going college student.
21.
21,
It is on a 125 CRPC.
21 and 18,
They retain majority
please.
as of now. What is wife's income?
Wife is running a school.
They say that, but she is now
running little Solemn Little Star
What did you
School.
write?
she is suffering from stroke now, my lord.
Huh?
She is suffering from stroke.
Shall be remanded to the line counsel appearing with the respondent. Submits of the matter is pending from 2021, and so far they have not received any amount. However, it is submitted that one son is age 18 and the other one is 21 now. 21 as of now. The order impugned is an ex parte order. There was no opportunity for the husband to contest the matter. He has not contest the matter. He is earning 1,05,000 as salary, and admittedly, right from 2020, he has not paid any amount. Though the children have become majors now, as on the date of filing of the application, they are minors. In that view of the matter, till the application is decided by the court, the petitioner shall continue to pay 10,000 per month, and the arrears also at 10,000. To respondent number to both the children till the day they attain the majority,
Please.
and which is subject to further orders to be passed. Without further notice, the party shall appear before the court on 15th of September, and they shall file the respective statement of assets and liabilities within 10 days from thereon, and the court shall decide the application by November 15th.
Please.
Yes.
13 urgent, 14 Somsekaraya Arti.
In this case, I have filed application for extension of
14.
petitioner is
Is
working
asking for
as.
time in the morning. Somebody was asking time in the morning.
Respondent might have.
No urgency for you?
My lord, now interim order is granted subject to deposit of the amount, my lord. Petitioner is a Zomato by my lord. Her mother was serious, she has admitted to hospital.
Order is obtained, that time it
I have
was okay.
deposited 1,20,000, my lord. Subject to condition, my lord.
Not there. This is matter.
Interim order is there, my lord. Extension of time, my lord, I am seeking.
Request of loan comes for the respondent. Let's this matter on 10th of September.
My lord, I have sought for extension of time to deposit the amount. Interim order.
How much time?
My lord, 2 months he is admitted to hospital.
24 order is passed.
Please, my lord. Now, my lord, because.
No, there is no interim order to extend because that day itself, within 4 weeks, when you have not.
My lord, I have deposited the maximum amount of 1,20,000. I have deposited.
But it long back.
My lord, her mother was, petitioner's mother was admitted to hospital.
Even,
Now he is in the hospital, my lord. Therefore, met with an accident, he is in the, even today he is in the hospital, my
We
lord.
will hear it when the matter is listed next time.
Please, my lord.
Yes. Next.
The date, my
15, sir.
Date.
Later, 10/9.
10/9 I will not be in station, my lord. Your Lordship. After 20th, my lord.
20th, 9,
Please, my lord.
29.
29.
20 is it's a holiday, 23rd of September.
Please, my lord.
Yes, 15.
I am for the petitioner hearing. As per the direction of this honorable court, I am filing the 3 years bank statement, my lord. And petitioner is also present before this honorable court, my lord. There's a direction to be present.
Serve him a copy.
Today, now, sir, coffee.
You want to get instructions?
You need 1 week time because
They have not
inconvenience.
filed, my lord. They have not filed the bank statement.
I will
Direct-
file, I will produce it. Party inconvenience to contact me, so I sent notice also.
As per the order passed by the court, the petitioner has filed the statement, the bank statement of the last years, but the wife has failed to file. The wife shall file the statement by 21st by serving the copy of the same on the other side. List the matter on 28th.
Presence of the petitioner will be kindly. There is a direction also to be present, my lord.
Why there is a direction?
Yes,
Give the
my lord. To explore the possibility of settlement, my lord.
She is not there.
Yes, my lord. No, my petitioner's presence may be kindly noted, my lord.
Who not?
Give that order sheet.
3 weeks before. Who not one, no, ma'am?
Then counsel for the petitioner submits that he wants to settle the matter by paying a lump sum amount. What about this? No instruction.
Inconvenience to contact two parties, therefore I sent notice also. I need 1 week or 2 weeks time.
And on the last occasion, it is submitted that the petitioner wants to settle the matter by paying a lump sum amount. This court has directed both the parties to be present. The petitioner husband is present. The land counsel for the respondent submits that he could not contact the client. Yes. Yes. Yes, next.
Serial number 16, Arun Govind Raj.
That is already adjourned in the morning.
16, adjourned. Serial number 17, Raghavendra K.
Petitioner, my lord.
We need some time to file our detailed objections, my lord.
No objections are required in a writ petition. Why you?
My lord, the reason is that they have stated certain things in their petition as well as
We
in
will
their.
not look at what they have stated. We will only look at the impugned order.
Yes, my lord. Done, my lord.
And then
My lord.
proceed with that. Only
Wife-
the impugned order, nothing else.
Yes, ma'am.
Yes, where is the
See,
impugned order?
My lord, impugned order, my lord, page number 53, my lord. My lord, wife file a maintenance application.
What is awarded?
Awarded, my lord, 5,000, my lord.
What is your income?
My lord, my income is, before COVID, I am working as a teacher, so a daily wages teacher, 11,000, my lord.
No.
Now I am not working, my lord.
Why?
See, my lord, after COVID, my lord, I removed from school, my lord.
How old are you?
See, my age, my lord, see,
You are 46 years old.
is 46, my lord.
46 years you will not work.
No, my lord, see, problem is, my lord, earlier I am working in school, my lord. After that, because of COVID, my lord, removed from school, my lord. It's a daily wages basis, my
What
lord.
is your wife doing?
My wife is a teacher and she has been teaching in a primary kids, pre-KG kids. She has basically
Sir, what is her income?
13,000, my lord. It is 13,000. It's mentioned in their assets and liabilities also as 13.
What is this income according to you?
My lord, I'm for the husband, my lord. The wife is a teacher.
Wife is seeking
Wife is
Maintenance,
seeking, yes, my lord.
enhancement of the maintenance.
Yes,
Enhancement, my
my
lord.
lord. Wife filed a restitution of conjugal rights petition. Husband filed a divorce petition, my lord. See, wife filed an application in section 24 of Hindu marriage, 50,000 rupees
So
of
earlier
maintenance.
you were working as, both of you were working as teachers.
No, no, it's a
My lord,
one
the
private
hus-
software company. His husband is.
My lord, the husband is working as in a private software company and he also owns a company. Now, the wife is a
Kind
teacher
permission of the
and she
court,
has
my
been working as a teacher since the beginning. Now, here, what the wife claims is that she only earns 13,000 per month as salary in the form of wages. However, they have suppressed the fact that she also owns properties and that she has been staying in her mother's property. Her mother had passed away very recently and the property has gone to her and her sister. And now she's staying there. She doesn't have to pay rent. And on top of it, there is another property that there are like certain houses, number of houses, and she also earns rent from that property. They have suppressed all those facts and they've simply stated that all she earns is 13,000 and that we are entitled to be paying her maintenance. Now, my lord, in the order, the trial court
What
judge.
is your income owning a company?
My lord, mine is close to
Page number 7.
1,46,000, my lord. Now, we were together for 18 years until my son completed his base level of education. And then I also provided for his further education. He just cleared his undergraduate course and he's now further planning to get into masters. He has been staying with me since the time we have been separated. Now, on top of that, my lord, there is one particular, in the order, there's a mention that at page number 61, my lord, the order of the trial court, there's a line which says, on the other hand, the respondent is owning a private company having 50% share and also having handsome income more than 1 lakh. The 50%, the rest of the remaining 50% belongs to her, which they have not disclosed anywhere. It belongs to her and she is also getting other income in these sources, which they have just completely suppressed all material facts, my lord. Is
So
that?
in your company, she's a partner.
Yes, my lord.
So what is her share you're giving?
50%, my lord. I own 50%, the wife owns 50%.
What is that? So something should be, because not on paper 50%.
Yes, I understood, my lord.
What is she getting?
That I'll have to take instructions on how the amount. Yes, my lord.
It is submitted with the counsel appearing with the husband that in the company, software company, which is owned by him, the wife is having 50% share. The counsel shall place before the court. What is that in the, what is the 50% share? How much amount she is getting towards her share, monthly or per annum? This is the matter on 28th.
Much obliged, my lord.
Obliged.
First. Yes, next.
Chair number 18.
For the respondent.
Transcribed order.
There is challenging the order of maintenance, my lord.
PHP Leeladhar has filed memo for retirement seeking permission. Has already filed NOC Wakalat. This is matter on so and so. Counsel for the respondent is present, no representation. For the petitioner, list is matter for dismissal. Any interim order in this?
No interim order.
List is matter on 4th for dismissal.
Chair number 19. 19. Bhushani Kumar for petitioner. Vivek Hulla.
As per the directions, I have deposited the amount, my lord. I have served a copy.
My lord, just one submission. They made a payment of only 30,000.
That is the direction that
My
was
lords had
given to
directed
me.
that the entire arrears from December till date will have to be paid. If I just read my lordship's order,
I thought that it is 30,000 to be paid.
they had
deposited.
indicated that since they have not made the previous arrears, they will additionally make a payment of 15,000 as directed by my lords,
But
plus
he's
another 15,000.
He is supposed to pay 15,000.
Yes, ma'am.
So he has paid 30,000.
My lord, from
Every
December.
month they will be doing it.
Yes, my lord,
that is what I-
but from December till date, he has not made any payment. Plus, over and above that, from the date.
But from
Yes.
December to till now, at 15,000,
Yes,
whatever the amount is, that from this month, he will be paying extra 15,000.
I understand, my lord,
He'll
but
be compensating it.
My lord-
No, that day before you only this order
I
passed.
understand, my lord, but my lordship's order had stated that he'll make the payment of 30,000. Over and above this payment of arrears from December till date, there is an arrears of additional 7 lakhs also that is pending, which if my lordship sees the
Again,
order.
you're going back to square one.
I understand, my lord, but my lords on
I've
read
seen
order
it.
9725.
That order is clarified only for the calculation purpose.
Correct, my lord, but
The
in
court has
para.
never said you pay that amount.
No, my lord, in para 4 and 5, my lordships may just peruse.
Last time also you have said
Yes,
the
my lord,
same
but we
thing.
hadn't brought it to the notice of my lords with respect to para 4 and 5. My lords had directed them to pay the additional 7 lakhs and they had taken time to indicate as to how they'll file a memo indicating the calculation with respect to that 7 lakhs as well. My lordship sees para 4 and 5.
He requires some time and the petition will come up with a memo of calculation.
Yes,
That's
ma'am.
it.
My lord, just one submission.
It's
It is
only your
not that.
submission, paragraph number 4 is your submission.
Yes, my lord, and para 5 is their submission indicating that they'll file a memo of calculation with respect to that.
As
Just
per
one
the
more-
order dated
My lord, just one more submission.
9/7/2025, the petitioner shall file the memo of calculation. Yes.
On the last day, they've been making a mention stating that the petitioner has financial constraints and he's not been working. If I may be
File the
permitted to file a
documents.
memo.
He is working.
He is working, my
According
lord,
to-
he is earning.
According to the land counsel to the respondent wife, the husband is working. In that regard, it is submitted that she has documents to show and she'll file a memo. So she shall serve the same on the counsel for the petitioner and file the.
I never said
file
that he is
before-
not working. He is working, that's why he could.
In fact,
make
in their
the
own
payment.
petition, they had made a mention
Yes,
that.
he's saying something. I said I only recorded. Yes. Yes.
Next,
List the matter on 2nd of September.
my lord, first, my lord.
First.
Till number 20. Veeranath Tigdi for petitioner, Venkatesh's, KP
For the
Bhuvan.
petitioners in this case, my lordship.
Yes.
My lordship, the matter has been settled, my lordship, before the trial court. I am filing memo, my lordship, with regard to that.
The memo is filed stating that the criminal miscellaneous 520 of 2022 on the file of the 6th Additional Family Judge Bangalore is settled as per the before the mediation center. Hence, in view of the settlement, nothing surprise for consideration. According the same is taken on record and dismissed as infractious. Yes, 21.
Till number 21.
The petition, my lords, I seek for a 2-week adjournment.
No, I'm opposing the adjournment, my lord. Last occasion also they have took the time.
The reason is, my lords, senior counsel.
You have an interim order?
No.
My lords,
You have an interim order?
interim order is that to pay the amount to the effect of 3,000, that we are paying it.
No.
What is the amount granted?
Amount granted was 6,000 each, for the.
So you're complying with the interim order?
Yes, my lord.
Is it correct?
No, my lord. Yes, he complied only to the extent of daughter. But as far as wife is
Daughter only,
concerned,
my
they have
lords.
not been paying. But to that extent,
Order of the court.
order to the extent of 3,000 is complied.
Yes.
But
At the request of
my
the
submission, my lord.
This is a matter has to be heard finally.
No, there is only meager amount is the last 20
Now,
years.
Please understand, it's an interim order. It has to be heard finally, isn't it?
No,
24 matter.
interim, madam. It's only 3,000 amount. He has
In a
filed.
6,000, when 6,000 is granted.
My
3,000
respectful,
is what-
my,
what do
my
you expect?
respectful submission is, he has filed a petition for divorce on allegation of adultery and cruelty. And taking that petition is 20 years and he without paying any amount. When he has lost his stand of cruelty, now he is making agitation to avoiding the maintenance. This is my grievance, madam. If she's
So
very.
please understand, court has granted 6,000. Interim order is granted 3,000 and is paying you. No, the matter has to be heard. Now, what do you expect the court to do? To ask him to pay 6,000 and then later hear the matter?
No, it has to
Then
be
hear
disposed
the
because
matter,
I need to
dis-
enhance the.
On, how can it be enhanced without your petition?
Now I hear that application is.
On 9th of September?
Great.
Yes.
Till number 22. 22, Nataraj BS.
For the respondent wife.
Writ petition is filed by the husband challenging the order of the maintenance granted by the trial court at annexure E, my lordship, in page number 46. I request this honorable court to turn to.
How much is granted?
Granted is that 10,000 each for 2 children and 1 wife and
20,000 per month?
Per month for each.
Per each. That is children 20,000.
Children 20,000, wife 10,000 plus 25,000 one
Did
time.
you get petition is directed to pay 10,000 each per month, maintenance of the respondent and the 2 children. So all 10 each.
10 each plus 25,000 one time litigations.
What
The
is
reason
your-
is that, my
What
lord,
is your income?
my income, I kind of peruse that in para number 12 of that judgment in page number 50, my
You
lordship.
can tell the court what is,
That 43,132 is the my net salary, my lordship.
Kindly see the gross.
what is the gross?
Cross is 86,000. After deduction of statutory deduction, I am getting only that 43.
Deductions, let's see. Where
Half
is your
of it.
Kindly I produce that
Half of
salary
it.
certificate,
Huh?
produce the annexure F, my lordship.
number?
page number.
Let's see, what are the deductions? PT, EGIS, LIC, GPF, Provident Fund, 10,000, your KGID. What is this KGID?
Insurance, my lordship.
Insurance, 5,544.
Are all,
All are, where are the other deductions?
No, your lordship may kindly say half of it showing as deductions. He has taken some loan or something.
Where
or
is
some-
that? That I'm not able to see.
This annexure F, that itself shows his total.
No,
gross
annexure
sal-
F, annexure F.
F. Gross salary was 86,959, almost 87,000. And sum of deductions, recoveries, 41,327. Almost half of it. How can that be? Only statutory deductions should be taken into account, not whatever voluntarily he pays. If he takes some loan, repays the.
I'm not able to understand. This deductions which are mentioned above, they will not be half of your salary. 10,000 plus 5,000, 15,000. The remaining are another 2,000, that is 17,000.
11,000 plus next recoveries is there, my lordship. You have raised the loan for the benefit of the family only, my lordship.
GPF recoveries.
GPF and KGID. We have taken the loan on that KGID amount, my lordship, for benefit of the family. Because that is also deducting my KGID this one. I have raised the
When
loan.
was the loan taken?
Pardon?
When was the loan taken?
Loan was taken around 7 lakhs something, my lordship.
When?
I don't have that much of details, my lordship.
Oh, well, from when the parties are living separately?
From past, my lordship. 2021, my lordship.
When is this loan taken? Land counsel for the petitioner shall get details when the loan is obtained and how much is the loan and what is deducted towards the EMI of that said
And
loan.
also his pay is revised now. That
And
itself
also
shows-
shall place before this court
Present,
his
1 lakh and odd is-
revised pay slip. Yes, this is a matter on
May
3rd
I
of,
make a submission? In this
this is a
case,
matter on 3rd of September.
may I make a submission? I have produced several documents along with the affidavit of assets and liabilities. Both of us have filed. He has not produced them here.
One
To
submission.
show our liabilities, wife's liabilities, she has produced several documents. Based on that, the trial court has,
My
he has
lordship,
not produced them
This
here.
matter, my lordship, I request this up to turn to in page number 47 for a moment. I request the lordship. The petitioner, their wife is a law graduate. She is practicing and also she is assisting to some NGOs. She is also earning. But I am no worry about the paying the amount to the children. I have paid 1.5 lakhs towards the cost of the education of the children. And also I paid the
So you have no difficulty to pay 30,000 to the children.
children, not 30,000, Mr. Because my aged mother is there. Out of my net salary, I am only living my life with
Get
30,000
those
rupees.
details, we will see.
That is
Yes,
the
next.
reason, my lordship.
Let him
23, Veerbhadraya MC for petitioner, Pawan Kumar S for respondent.
Yes.
Petitioner. And someone's has served, my lord.
He's appearing. He's appearing.
Not
File your wakalat also?
Filed my
Ah,
wakalat.
Yes. Not necessary, respondent is here. That not necessary, respondent is here. Yes. Argue.
Lord, I am, according to the Salma Court, I am paying the 13,000 rupees every month.
No, he's appearing. We can dispose of the matter if you argue. This is a matter on interim order is complied with.
My lord, I don't have instruction about that. my lord.
Land
I'll take
counsel
it.
for the petition submits that the interim order he is complying with the interim order. Land counsel for the respondent submits that he has to get instructions in this regard. List this matter on 10th of September. Interim order earlier granted is extended in them. Yes.
Cell number 24, urgent 25, final hearing. DS Umesh for appellant, Gopal Krishna N for respondent.
Yes, Mr.
I pay for respond in this case, my lord.
My lord, it's a case of cancellation of policy, my lord, because of check bounce. My lord, I will come with decisions, my lord. Can I seek some accommodation? I am not keeping well, that is the reason. I will come to the court itself with decisions, my lord. Subsequently, my lord, the insured has obtained another policy. He is aware of the, my lord, cancellation of policy. Next Thursday, my lord, if my lord is.
View that, view the proceeding sheet.
Yes, ma'am.
We have examined an officer, my lord. We have also produced the documents, my lord, to show that the notice is issued.
List his matters on Friday, on the next Thursday. No further adjournment at
Yeah,
any
please,
cost
please.
to be granted.
Much obliged.
48, cell number 26, Chandrasekhar HP for
For the
appellate.
petitioner, my lord, kindly pass over, my lordship.
No passover. What is the matter about?
I'm not having the file, my lordship, N4, my lordship. Kindly pass over, my lordship.
Get the file immediately. We'll call in the, not in the afternoon. Now in after 10 minutes, we'll call, get the file.
Grateful.
Yes, 27.
Cell number 27,
Where is Pradeep?
27 Pradeep B.
Yes, we'll hear the matter. Arvind.
It's a claimant petition. The only contention taken by the appellants in this case, my lord, it is the only the deceased has a statement made.
What are the grounds? Let's see the grounds that are raised.
The grounds is, my lord, in the second paragraph, as per Exhibit P11, record of Father Muller Hospital. That is the second hospital referred for the accused deceased in this case. He succumbed to injuries in the Father Muller Hospital, Mangalore, where the relatives stated that his history is fall from height at 8:30 p.m.
Pradeep, where is Mr. Pradeep? Huh? Where is Mr. Sivanagowda? He appears. Inform them the matter is here. Short passover. We'll take up the matter.
Yes. Cell number 28, Raju S.
This also Pradeep's matter, passover. Yes, come. Yes, Pradeep. Next, first matter.
27, 26, huh? 27.
Lord, this case, my lord, challenging the liability
Hmm.
on the ground that, my lord, as per the Exhibit P11, hospital, Father Muller Medical Hospital, clearly goes to show that, my lord, the history of fall from height on 8:30 p.m. on 2/10/2017 near Shumaga.
Hmm.
They have contended that, my lord, he was working a
Exhibit?
Exhibit P11, my lord.
Death summary of Father Muller Medical.
Father Muller.
Hmm. Hmm. It was a fall from the height.
Please.
Hmm.
That is.
Take that.
It is there.
Alleged fall from height at
Fall from
8:30 p.m. on 2/1/2000. When is time of the accident? Date of the accident?
No, date of accident is 2/10/2017.
2/10/2017 is the accident.
Yes, my lord.
When he was taken to the hospital?
My lord, in Father Muller, my lord, 10/10/2017.
Huh?
Father Muller, my lord, he has admitted in the top, my lord,
Uh-huh.
10/10/2017.
10/10.
10/10.
What
The
has happened between?
history of accident, before that, my lord, one more MLC is also there. Before that, MLC Nanjapa Hospital, my lord.
That is exhibit?
That is Exhibit P12.
P12.
P12, my lord. There, my lord, the history of accident mentioned as self-fall from tractor.
Where do you get that?
Middle, my lord. History of accident, MLC, it has written MLC, Exhibit P12.
No, I am looking at page 71.
Nanjapa Hospital.
Seven.
Nanjapa Hospital.
Father Muller Medical Death
Next
Summary.
page, next page.
So this is also Father Muller. Nanjappa Hospital.
Nanjappa Hospital, Annegowda,
Here, 2/10/2017.
2017. Here in this,
Time 9:50.
they have mentioned
Immediate-
that
What is the, you said the time of the accident is?
time of the accident at,
Look at the,
please, madam.
ten to 10/2017, that's what it is.
8:30.
8:30.
8:30, madam.
And he was taken to this Nanjappa Hospital.
Nanjappa Hospital.
At 9:50.
Please, madam.
Self fall from tractor
Tractor.
at around 8:30 PM on 2/10 year so and so. Yes. Then thereafter, what happened in this hospital?
Thereafter,
He
my
was,
lord,
he was how many days he was in this hospital?
2 days, 8 days, my lord. 18/10/2017 is died, madam. He was died. 18/10/2017. He was dead.
No. 2/10/2017 is a date of accident.
Please,
Then
madam.
10/10/2017 is a Father Muller.
Father Muller Hospital.
That is for the postmortem.
No, my lord, they are admitted for injuries only. After taken
So
treatment, my
from
lord,
2/10/2017 till 9th, he was in this hospital. In Nanjappa Hospital.
Nanjappa Hospital, my lord, he was taken treatment. When he has discharged, one second, my lord. CT scan and all everything is. Nanjappa Hospital discharge summary is not produced.
Now come back to exhibit that Father Muller Hospital.
Father Muller. Alleged history of fall from height at 8:30 PM on 2/10/2017 near Shumaga.
According to the case of the claimant, what it is now?
My lord,
According to the claimants, what it is now?
they are telling that, my lord, in the complaint, exhibit P2,
Then when is the FIR?
please.
FIR date?
FIR, my lord, on 18/10/2017, my lord.
1810.
7/10
No, no.
information is given, my lord.
8:10.
8/10, my lord.
8:10.
FIR is on
He
8/10/2017.
died on 1010.
He died on, my lord, 18/10, my lord.
1810.
18/10.
Hmm.
Complaint
So
was
let's-
lodged after lapse of,
What did they say?
my lord,
Days.
6 days.
What did they say in the complaint?
ಫಿರ್ಯಾದರ ಅಣ್ಣ ಪಣ್ಣೇಗೌಡ 52 ವರ್ಷ ಇವರು 2/10/2000 ಫಿರ್ಯಾದರ ಕರಿಬಸಪ್ಪನವರ ಜಮೀನು ಕೂಲಿ ಕೆಲಸಕ್ಕೆ ಹೋಗಿದ್ದು 8/30 ಕರಿಬಸಪ್ಪನವರು ಸಲ್ಲಿಸಿದ ಅಡಿಕೆ ಮಣ್ಣಾಳ್ ಗ್ರಾಮದಿಂದ ಬಳ್ಳಾಪುರ ಗ್ರಾಮಕ್ಕೆ ತಲುಪುವ ಸಮಯದಲ್ಲಿ ನಿಖರ ಸಮೀಪ ಸದರಿ ಟ್ರಾಕ್ಟರ್ ಟ್ರೇಲರ್ ಅನ್ನು ಬರುತ್ತಿದ್ದ ಟ್ರಾಕ್ಟರ್ನ ಡ್ರೈವರ್ ಪ್ರಕಾಶ್ ಸದರಿ ಟ್ರಾಕ್ಟರ್ ಅತಿವೇಗ ಜಾಗೃತಿ ಮಾಡಿಕೊಂಡು ಟ್ರೇಲರ್ನ ಹುಕ್ಕು ಕಟ್ಟಾಗಿ ಟ್ರಾಕ್ಟರ್ನ ಕಟ್ಟಾಗಿದ್ದು ಪರಿಣಾಮ ಫಿರ್ಯಾದಿಯವರ ತಂದೆ ನ್ಯಾಯ. He was working as a coolie under one Kariyappa, who is the landowner. After completion of work, my lord, he has traveling along with that Arakanets. When they are coming near Bannikere village, at that time the driver of the tractor who drove the vehicle in rash and negligent manner turtled. Going to the impact, my lord, he has fell down from the trailer.
Now, how this evidence is dealt with by the court? Please come to the order.
They are stated that, my lord, he was a coolie. They are
No, how it
contending.
is now, how this exhibit P11 or what, P11 and 12 or 12 and FIR, what
Please,
are
ma'am.
contradictions are dealt with by the court? Paragraph number?
Paragraph, my lord. Paragraphs, my lord. Paragraph 17, my lord. 16 onwards, 16 and 17. RW2 in his cross-examination deposed that the deceased was coming for a coolie work every day on 2/10/2017.
RW2 is the owner.
Owner. RW2 is the owner, my lord. come for coolie work on RW2 in his cross-examination admitted that the accident occurred when the deceased was sitting on the trailer and due to the rash and negligent driving of the driver of Prakasha and the deceased succumbed to the injuries on 18/10/2017. RW2 during the course of cross-examination by counsel, the second respondent deposed that on 7:30 to 8 p.m. he came to know about the accident and he did not give police complaint and MLC was registered. He has deposed that he has accompanied with the injured Mangalore Hospital. RW2 deposed that the deceased used to come coolie work during the Arakanat season and he has maintained the account book relating to the salary paid to the deceased. RW2 further deposed that and the hospital he has informed that the injured fell down from the tractor due to the breakage of
Paragraph number 17, above 3 lines, paragraph number 17, that is above paragraph number 18 immediately. He says, RW1 further deposed that in the hospital he informed that the injured fell down from the tractor due to breakage of hook of the tractor and the trailer. There is another story. He says because of the, according to them, because of sudden break or something, the accident has happened. Second story is this. Third is from the height.
From the height.
Uh,
From the height. And Nanjappa Hospital fall from tractor.
hmm.
During the cross examination, I had to try to establish
The court has not gone into that aspect of exhibit P16, P11, P12.
No,
What do you
madam.
say? Mr. Counsel. Counsel for the respondent. What do you say?
Millard, the fall from height contention is not at all raised in the court below. The only two contention they are right.
No, there is evidence on record.
Ah,
No, it
Millard.
is for the court. No. Exhibit P11 is marked by you. Exhibit P12 is marked by you.
Yes, my
Then
lord.
FIR,
Yeah.
P11, P12, FIR, all different versions.
My lord.
RW2 gives another version, employer.
The prior two crucial documents before the discharge summary in the primary.
What I want to know is immediately after the accident,
Yes, my lord.
which is the first document?
First
Document.
is FIR, my lord.
No, no, no.
FIR and
Document is on,
complaint is there, my lord.
complaint is on 8th.
Exhibit P3.
Is on 8th. It's not a first document.
They have not lodged the complaint immediately.
So you can't say that's a first document. First document is
Exhibit P12.
exhibit P,
12.
exhibit P11, I think.
12,
Muller,
madam.
Max Muller. No, P12.
P12.
P12 is that, what is that hospital?
Nanjappa Hospital.
Nanjappa Hospital.
MLC.
P11 is?
P11 is
Father Muller
So
Father Muller
somewhere
Hospital.
P12 or P11 are in connection.
Yes, my lord.
So
But
it appears that for the purpose of getting the compensation, the story is cooked up.
No, my lord. Actually, they are illiterates. The hospital authorities, what happened is the hospital authorities asking in English, they were in the hurry, they were still that fall from height.
Then you should
Fall-
do something, you should call for the, you
My
should
lord,
do, you should
the
give
fall-
some evidence.
No, the fall from height means due to the breakage of the hook of the trailer. Why should he fall? It is actually an accident. It is
Why should he, if somebody falls from a height, it can be, that is an
the
accident.
the owner, the employer has admitted that he is attended the coolie. He has worked on his avocation as a coolie for daily wager in the owner of the vehicle. He has admitted. More,
No, if you see, without their knowledge, all these things will not be entered into the MLC. Nanjappa Hospital, one thing.
Yes,
When it comes to, at the time of the Max Muller Hospital, again, another story, two stories.
Yes.
FIR 3.
already MLC.
RW2, the RW2 says something else.
The
No,
reason.
RW2, what he says, that the injured fell down from the tractor due to breakage of hook of the tractor
Yes, ma'am.
and the trailer.
Yes, ma'am.
Whose case is that? Please come to the petition. Let's see the order. What did they say? The hook of the trailer attached to the tractor broke and the trailer fell down. The deceased who was sitting on the trailer. So this is the consistent case as per the claimants.
Please.
But now your
So
own
Mr.
documents are speaking against you. You should have examined somebody.
No, my lord, in the cross exam, the reason for delayed in FIR is because MLC has been already
We're
registered.
not going into the delay. We are not at all going into the delay.
Yes, my lord.
We are only looking at immediately after the accident.
Yes, my lord.
When they are disputing the accident, what is the document immediately after the accident? that is Max Miller Hospital. That what it says?
Max Miller Hospital is the
Not
second.
Max Miller.
Father Muller.
No, for the
Nanjappa
Muller.
Nanjappa Hospital
Nanjappa.
document
What
is
did you
first.
say in Nanjappa Hospital? Read it from Pradeep, you have that?
Please. Nanjappa Hospital documents, my lord, alleged history of self-fall from tractor.
It's an alleged history, which is only the
Alleged history of self-fall. That is one. Next, for the Muller Hospital.
in the Father Muller Hospital also, they have
History of fall from height.
history of fall from height, but reason for falling from height is due to this accident only. Due to
do we
breakage of the hook, my lord, the similar case has been recently covered by this honorable court. Fall from height.
Take it.
The page number 4, my lord.
Page number?
4. The appellant only basing on a bare statement.
Page number?
4, my lord. In the citations, it's a 4 number, page number 4.
Yes.
7th paragraph, after few lines, the appellant only basing on a bare statement that is mentioned by the hospital authorities in progress record, which is part of exhibit 11, that respondent number 1 informed that he sustained injuries due to self-fall, is before this court.
You are reading paragraph number?
7,
my lord.
7 from the middle
7
line.
after fifth line.
7.
Fifth line, my lord. In the 7th paragraph, 5th line, my lord. The appellant only basing on a bare statement that is mentioned by the hospital authorities in progress record, which is part of exhibit P11, that respondent number 1 informed that he sustained injuries due to self-fall, is before this court. However, the same hospital authorities have mentioned in all other medical record, which includes exhibit C, wound certificate, and exhibit P7 discharge summary, that respondent number 1 is admitted to hospital with alleged
Is
history
it
of.
same?
Pardon?
How this is same with this case? Their own documents
Yes,
are having different versions. That's why the court has taken that view.
But
here, there is no inconsistency.
But the statements made by the parties in the FIR is crucial, and also complaint and other documents is
Because
crucial.
there is a delay.
Because, my lord, what happened is actually they are not conversant with the English. The Father Muller Hospital and Nanjappa Hospital authorities, what happened actually, the doctors usually asking in a lighter manner what happened. These people are illiterate. It's fall from height. They did not go to elaborate explanation. So these complaint and other things are important. But here it is in Kannada version.
Complaint we can understand if it is immediately given. Then we will say that it is not rightly taken by the doctors, but it is not immediately.
My
It's
lord,
after 6
one
days.
crucial aspect, my lord. Can we interpret like this? Why should he self-fall intentionally? He is a coolie. Due to that accident only he is self-fall. It's actually wrongly noted as self-fall. Why should he self-fall at all? Due to the impact of the hook.
Self-fall means that not that he wantonly he will jump.
Yes, my lord.
Self-fall means without anything, because some mistake, like he fell down accidentally.
The vehicle is damaged is also on record. Due to that damage only he has self-fall. The vehicle, the coincidence, without vehicle's damage, if he self-fall, it is different matter. That is, the canvassed argument is suitable. But the tractor hooks cut and the damage of the vehicle is also crucial. Because of the damage of the vehicle only, the trailer has been subverted and he has injured, my lord. Seriously injured. He succumbed to that one. Without damage of the vehicle, how can he fell down? The two incidents should be taken simultaneously.
What are the other exhibits?
Pardon, Mila?
What are the other exhibits? With regard to the vehicle and all, what are the other exhibits?
No other vehicle. Actually, it is.
No, I'm saying with this tractor, what is IMV report, exhibit P10? Give that. IMV report.
No
exhibit
fresh
P10.
visible damages found at the time of inspection.
Huh?
No fresh visible damages found at the time of inspection.
When it was done? Date of that report?
Date of report, my lord. 12/10/2017. 12/10/2017.
Yes. Now, second, now you say that there is damage to the vehicle. As on that day, there is no damage.
Another one, my lord. Come to page number 82 in the document. It is
Right,
an Nanjappa
record.
Hospital admission card, where it is clearly marked that accident.
Where do you see?
At page number 82, my lord. In the LCR. Exhibit ಹಾಕಿಲ್ಲ ಇದರಲ್ಲಿ. It is an admission card, my lord.
Yes, Pradeep.
Here it
Exhibit
is
P18.
mentioned clearly, it's an accident. Another one column is there, fall and injury, that has been not rounded. It is the accident which is rounded here also. Poisoning, assault, accident, fall and injury. If at all, if they have taken contention that is fall from height, it has to be marked. It is an accident, it is rounded and marked. It is a very preliminary document, even before the discharge summary and everything else.
History has not stated there anything. They have just mentioned accident. There is no mention about the history.
Accident means
Dated when it is at 2/10/17 at 9 PM. This is the admission card.
Yes, madam.
9:50 PM.
The same day MLC has
No,
been
after
issued.
that, the MLC has come. So
The same day MLC has issued.
correct, but first this would be, no, it says fall from tractor, accident is rounded off. All other things, fall and injury, 4 is fall and injury. If that is what they say, it should have been marked, rounded off.
Please, my lord, accident is concerned, my lord.
Also fall from by a tractor is accident, fall from tractor.
If he is traveling in a tractor, my lordship, full bench judgment of our Honorable Court has.
So he's a coolie, tractor is from the.
Please, my lord, if he is traveling in a trailer, if he is traveling in a trailer, then my lord.
The fall from, if the
No.
contention fall from height is taken.
Tractor and trailer, when in a normal sense, when somebody says, nobody says that I'll fall from the trailer. They say fall from a tractor.
But everywhere, my lord, it has mentioned that, my lord, fall from tractor. If it's traveling in a trailer.
The owner says that
And
he's working, he has a book maintained to show that he's regularly working.
They
as
have
a
not produced
coolie.
that document.
He's working as a coolie in his, and nothing contra is elicited from his evidence.
My lord, manner of the accident, the complaint which they have narrated is that, my lord, the tractor and trailer capsized, my lord, due to the
Capsize, we said.
please,
No.
my lord, turtled.
They're referring to
There
the
should
link
be an
between
damages now, my lord.
the tractor and the trailer.
Please, my lord. You were sitting on a trailer in the complaint. In the complaint, he was sitting on a trailer only.
He is supposed to sit in the trailer because he is a coolie. It is loaded baggages are there.
There is no problem with that. He's sitting on a trailer.
Please, my lord, but
What they say is.
the impact is, my lord, tractor and trailer towing ring cut off, my lord. Due to that, my lord, he has fall from the trailer as per the complaint. There should be damages to the tractor and trailer, both, my lord.
No, what it will happen, if
The
the link between that is broken, why it will.
The story has narrated in the complaint, my lord, but not in the medical documents.
Medical documents also, first document, we have to look at the
First document, accident fall from tractor only, my lord.
So
In
tractor,
the second
you can't
documents also,
consider
in
it as-
MLC also, same thing has been mentioned.
There is clear option there.
MLC also, same thing has been mentioned. No changes in MLC, my lord. Same thing has been mentioned in the MLC also.
But MLC, they failed to say accident, they said self-fall.
Self-fall, history of,
That is, there is something wrong in mentioning it. Because immediately, accident is at 8:30, this document is at 9:50.
950 only, my lord. Both they have written in the 950 only. The MLC also, history
Then
of
we have
self-fall
to
from
say-
tractor.
Then we have to say,
In admission card also, same thing has been mentioned. Accident, self-fall from tractor.
no, accident.
Accident has round off that in admission card.
It's not round off. There are accident, poisoning, assault.
Yes, madam.
6 options are there. So
Only
which
they
one
have
it is?
rounded off in the accident.
That means accident.
Similar liberal contrition may be taken if the accident is blurely, simply rounded off. That is fall from injury also due to the impact of that. The liberal,
That is one aspect. Then the next contention,
my lord, in the cross-examination part, in the
let him say. What is the next contention?
Next contention, only we have urged before this court.
Only on that.
ground.
And
There is no relationship, my lord, then owner has admitted that
then that is
relationship.
one aspect. Then what about you're not on the compensation? Nothing on
No,
compensation. Yes, please come.
MSCIs rightly consider the
My lord,
income. and all.
The agreed-
cross-examination is also there, crucial part in page number 80, my lord.
I have read it. I have read it in, that is extracted in this. Agreed with the order passed in, about passed in ECA number 5 of 2018 dated 23rd November 2021. The insurance company is before this court. The respondent herein has filed a claim petition under section 22 of the Employees Compensation Act, seeking compensation of rupees 20 lakhs along with 18% interest for the death of the deceased in the accident that took place on 2/12/2007 during the course of the employment. The case of the claimant is that the first claimant is a wife and the second and third claimants are the daughters. The deceased was doing coolie work under the respondent number 1, who was his employer. As such, there existed employer-employee relationship between them. The employer is engaging the services of the deceased as coolie for loading and unloading wet areca nuts to the tractor trailer. On the date of the accident, that is on 2/10/2017, the deceased was transporting wet areca nut belonging to the respondent number 1 from Musnal village to Bullapura village in tractor trailer, driven by the driver, 1 Prakash. Due to the rash and negligent driving of the driver, the hook of the trailer attached to the tractor broke and the trailer fell down. The deceased, who was sitting on the trailer, fell on the ground and sustained grievous injuries to his head, and immediately was shifted to the hospital at Nanjappa Hospital for treatment. Later, he was admitted at Father Muller Medical College Hospital and he succumbed to the injuries on 18/10/2007 at 5:50 am. The tribunal has held that the accident had taken place during the course of employment and as such is entitled for compensation of 5,95,000. 5,95,000 as compensation. The employer is examined as RW2. He has stated that he was engaging the deceased for as a coolie from a long time. And it is his case that because of the negligence of the driver of the tractor, the accident had happened. The next para, the insurance company is before this court mainly on the ground that in Exhibit P11, Exhibit P11, that is Father Muller Medical College Hospital, where he was admitted on 10/10/2017. It shows that alleged fall from height at 8:30 p.m. on 2/10/17 near Shimoga. And they're also relying on Exhibit P12, that is the wound certificate. It is
Admission card, my lord.
Outpatient,
no.
exhibit 12,
R12.
outpatient treatment details, admission card.
12 is Exhibit P12 is outpatient details, wherein it shows that self fall from tractor at around 8:30 p.m. on 2/10/2017 near Musnal village, Shimoga. Basing on these two documents, Land Counsel for the insurance company submits that it is a clear case that it is a self fall, and it's a cooked up story for the purpose of claiming the compensation. It is submitted that the complaint is given on 8/10/2017 when the accident had taken place on 2/10/2017 in concern as it is stated in the complaint with regard to how the accident has taken place. Then counsel submits that the Exhibit P11 and P12 are filed by them And when the documents which are relied on by them, are going contrary to their own pleadings, the claimant ought to have examined the witnesses, why why in those documents it is stated as self-fault. It is submitted that the tribunal has failed to consider all these aspects and granted the compensation. It is submitted that the award needs to be set aside as the accident had not taken place during the course of employment. Next part. Learned counsel appearing for the respondent claimant submits that the first document that is the admission card at 9:50 p.m. in Anjappa Hospital, it clearly shows fall from a tractor is a accident. She submits that the other documents where they have only stated about fall from the height, but the first document clearly shows it is an accident. As such, much credence need not be given to the exhibit P11 and P12. It is submitted that there is a consistent evidence of RW2 whose employer has stated that he has been engaging the services of the deceased as coolie in his tractor from a long time. And all these things clearly shows that the accident has happened during the course of employment and is entitled for compensation, and the court had rightly granted the compensation and no grounds are made out to interfere with the well-construed order as per the court. Next paragraph. Having heard the counsels on either side, peruse the material on record. This court has perused exhibit P11, exhibit P12 and also exhibit P18. Of these three documents, exhibit P18 is the admission card, which is the first document. In that, it is clearly shown that fall from a tractor accident. And as rightly pointed out by the learned counsel for the insurance company, in exhibit P11, P12, the version that is shown is different, and the FIR is on a later day, that is after 6 days. This court finds force in the argument of the learned counsel for the claimant that exhibit P18, it is very clear that it's a case of accident, and which is the first document immediately after the accident. Further, the evidence of RW2, who is the employer, also strengthens the case of the claimants. In that view of the matter, this court finds no reasons to interfere. Accordingly dismissed. What about the next matter?
Cell number 28. Raju, yes, 28.
Yes.
Claimant supplement. Case of death. Income taken by the tribunal 12,500.
It's a case of death.
Case of death, Mala.
You're seeking enhancement.
I'm seeking enhancement.
Date of accident?
Date of accident 2018, Mala.
2018.
18.
Age?
32 years.
32 years. Income is taken as?
12,500.
12,500. He's a
Rightly
paint
taken.
worker.
Rightly taken.
He's earning 30,000 per month.
Escalation, everything is there.
Then-
My underfriend is relying upon exhibit P23. One endorsement issued by one Babu painter, proprietor. The said documents, my lord, except that, my lord, salary
Not
certificate,
examined anymore.
not examined.
Not examined, unfortunately, not examined. My lord. He's a paint worker. He's
So,
trying to. A passbook also. I marked the passbook also, that bank passbook. And trial court has taken 1/3, 4th dependent is there. My lord. My wife, son, minor son, father and mother. One third has been taken by the tribunal.
So, now as far as loss of dependency is concerned, no, let's calculate. Now it is 12,500
Yes.
plus 40% future prospects comes to
17,000. 70,500
5,000, my lord.
total.
5,000. That is 17,500.
17,000.
How many are the dependents?
Four dependents, 1/4 has to be taken.
Hmm. It comes to 4375.
4375.
Minus 17,500. It comes to 13,125 into 12 into
16.
it comes to
25 lakhs 20,000.
that is another 3 lakhs added there. Loss of dependency.
And minor son law and affection has been awarded.
How many children?
One children, minor child.
Minor
Child and
4 years.
minor child and how many?
44 has granted,
44.
my lord. In the table may kindly be seen.
No, he says 4 claimants. Here it is granted for 3 people.
3 people.
4 claimants are 4 into 44. It comes to 1,76,000. Then 36,000.
Yes.
10,000.
Some more amount to be raised. Income. Regarding income. This paint worker is engaged.
27 lakh 42,000 from 24 lakhs
14,870.
870. Please come. Agreed with award passed in, and this is number 331 of 2018, dated 4th June 2022, whereby the court had granted compensation of an amount of rupees 24 lakhs 14,872. The claimant is before this court. Then counsel appearing for the claimant submits that the court had failed to consider the salary basing on exhibit
Exhibit P23, my lord.
exhibit P23 at what is that?
30,000.
That is, my
P23
lord,
that is at 30,000.
the endorsement, please.
That is at 30,000.
Endorsement issued by Babu Paint.
That is at 30,000. It is submitted that the court had when the four claimants are 4 in number, 1/4 has to be deducted. And further, the court had failed to grant the consortium, loss of consortium for 4 people. Instead of that, it is granted only for 3 claimants. It is submitted that the compensation that is awarded by the tribunal is not a well considered one and needs to be enhanced. Next, then counsel appearing for the insurance company submit that court had rightly considered and granted the compensation and no interference is called for. Next, having heard the counsel's on exhibit, perimeter. Then counsel is relying on exhibit P3 endorsement issued by Babu Painter that the claimant, the deceased, was earning 30,000. Except marking exhibit P23, he has not examined anyone. In those circumstances, this court is not inclined to consider the same. Then, coming to the accident had taken place in the year 2018. As there is no other evidence, as per the chart, the evidence as the income has to be taken as 12,500. Considering the age of 32, future prospects at 40%, comes to 5,000. That is 7,500. And there are 4 claimants, 1/4 has to be deducted towards personal expenses. That is 4,375. Then his contribution to the family is 13,125 into 12 into 16. Under the head of loss of dependency is entitled for 25 lakhs 20,000.
Fourth respondent, fourth petitioner is grandmother, my lord.
Huh?
Grandmother. That's what, my lord, I am thinking. Somewhere it is going wrong. Like. Grandmother, how can they entitle, my lord? Grandmother only, my lord. Kindly see, my lord. Para 27, my lordship. Internal page 13.
Futile exercise. Then everything remains to be the same.
Please, my lord. Para 27 may kindly be seen, my lord. If they are entitled, my lord, they are entitled, my lord.
Land counsel for the respondent submits that the fourth, the land counsel for the insurance company contentions submits that the fourth claimant is a grandmother. That's why the court has not considered and not granted, and there is no illegality with the said order. This court has perused the order passed by the tribunal and struck off everything. Heard the counsels on either side, there is the material on record. The a perusal of the order passed by the award passed by the tribunal, and the table discloses that the court had considered all the aspects and granted the just and reasonable compensation. In that view of the matter, no interference is called for. As far as that, not examining the, that let it be. Let it be. Huh? No, after that, as far as exhibit so-and-so is concerned, that painter, nobody is examined, that you let it be. Okay? Yes. Same. Dismissed. Next.
Another one,
Huh?
fourth one, last 11 affection has to be fourth dependent.
Everybody, great grandmother, everybody should be added now. Yes.
Case number 29.
Yes, 29.
29.
My lord, I am for the second respondent, my lord.
Yes.
Appear for in this case, my lord. It's a case of death, my lord.
Seeking enhancement.
Yes, please, my lord.
The
Date of accident 24/6/2019, my lord.
Hmm.
Offending vehicle lorry, my lord. It's a minor death case, my lord. Two dependents, mother and grandmother.
What is the age?
11, my lord.
11 years.
Yes, please, my lord. I'm relying upon Supreme Court judgment Kajal versus Jagdish, my lord. It's kindly given in the paper on the last occasion, my lord. It's there in the file, my lord. Para number 20, my lord.
Para number?
20, please, my lord.
This is a case of death. The Kajal is not a case of death.
But it's a 100% disability case, my lord. She is fully vegetative state.
That's a different aspect.
Yes.
And how will it apply to a death case?
No, my lord. How much notional income ought to have been taken? That has been explained in this para, my lord.
That is in case of the injuries.
Injury.
This is a case of death. This is a case of death.
Yes, my lord. Present case, a case of death. Kindly may I leave 2 minutes, my lord. I'll answer.
I can understand why the court has taken the notional income is in a case of because the considering the 100% disability,
yes,
that's how it is calculated.
Yes, please.
According to you, it will apply in a case of death also.
Yes, my lord. The appellant has placed before us material to show that the minimum wages payable to a skilled workman is rupees 4,846 per month. In our opinion,
D. Vijay Kumar.
What is
My lord, I have relied upon the recent judgment, my lord. I have given the copy of my lord Meena Devi and Nanucha. My lord, whatever the compensation awarded 5,60,000 is just unreasonable. And also I am relying upon the
that
judgment.
Is Justice Maheshwari's judgment, Meena Devi.
Yes, my lord. Yes, my lord. I have given the copy, my lord. I have given the copy.
Just
And
Meena
also
Devi.
several judgments of our High Court
We have
also.
Kishan Gopal.
Kishan Gopal following.
Kishan Gopal, Meena Devi, 5
Yes,
lakh 50,000, I think it is.
Yes, my lord. Yes, my lord.
There is a difference of 50,000 between those two. There are two judgments, Kishan Gopal, I think, and Meena Devi. There is some
50,000
difference of 50,000
because of the age. Yes, but here 5,60,000 is awarded. That is just unreasonable.
No, my lord.
In fact, this is the fifth attempt made by my learned friend with different judges.
National Insurance
We
Company
wanted to
versus
take chances
Rajendra
of all
scheme.
the judges.
They have revised the Kishan Gopal. In Kishan Gopal, 30,000 was considered. In this, 36,000 is considered.
in Meena Devi.
Meena Devi also, my lord.
Followed.
This
But
is
there
on.
No. There is some increase in the amount between that and
My lord, why that
Yes.
is there, my lord? Mother
Depends
age,
on the age,
has
age.
considered on that.
in the earlier
Mother
one.
age, Kishan Gopal.
Yes, my lord.
They consider the 30,000 per annum income. And that case, my lord, what is the mother age? That multiplier has been applied. That's why it varies.
This judgment in Meena Devi's judgment, what they did was
5 lakh is awarded.
1 minute.
Para 15 of the judgment.
Accordingly, this appeal is allowed. The amount of compensation is enhanced by so and so. The total amount. So how much it will be? It will come.
5 lakh only, but 5,60,000 is awarded by the tribunal.
So he's relying on how much it becomes. Samprati.
Recent judgment.
How is it calculated?
They have taken 36,000.
Is there? per annum income into
15 multiplier.
15 multiplier.
15 multiplier.
into 15 multiplier.
Yes.
Same, my lord. Only the income portion is escalated from 30,000 to 36,000.
That's only
That's all.
difference.
That's all.
So in this case, so it's the same thing applies.
Same thing.
36,000 into 15 is 5,40,000.
That's all.
In this case, already 5,60,000 is given.
Yes, my lord.
In your
Yes, my lord.
case.
Yes, my lord. We've come on appeal, my lord. Kajal versus Jagdish case, according to that,
That will not apply. The whole basis for that case is because a girl or a girl of that age is completely paralyzed. In those circumstances, the calculation is made.
but a vegetative state, my lord, almost like a,
She is living.
yes, my lord.
Problem there, the issue is she is living still. Here, the person is he is no more.
Yes, she is no more, my lord. I'm really also Honorable High Court of Karnataka, my lord.
With judgment?
Reported.
Sanjay Gowda judgment is now before the Supreme Court.
Yes, my lord.
Mallikarjun's case and all, where all will they go?
It's pending, my lord.
If you want, I can adjourn the matter, but I can't, I'll not apply those judgments. If you want, I can take a chance after some time.
My lord, like that only the matter is being adjourned from time to time before all the judges.
Mr. Vijay, you cannot say that. You ask so many adjournments every day.
Allah, not on this ground. Not on this ground.
Take a chance.
Yes, please, ma'am.
List this matter on November 4th.
Much obliged.
First of all, counsel the petitioner.
Much obliged.
Yes.
Chair number 30, Ashok and Patil.
Number 31 current in this case.
Yes.
Swami.
I appear for respondent number 1 to 4.
You're on what ground?
Last time, Manoj, I had argued on that contributor negligence, the pedestrian crossing the road, the pedestrian crossing the.
We'll read that.
Please.
Where is which paragraph?
Paragraph number 9, Manoj.
Please read.
Paragraph number 9, Manoj. The general rule is that the vehicle should be driven at a speed which enables the driver to stop within the limits of his vision, and failure to do so. To do this will almost always result in the driver being held responsible for the collision. In other words, it is the duty of the driver of the vehicle to keep a good lookout. In this regard, perusal of exhibit P5 spot sketch indicates that the deceased had already crossed 90% of the road and was hit by the offending vehicle, which he was just a few feet away from reaching the other end of the road. Further, the said exhibit also reveals that the driver of the offending vehicle had a clear line of vision and could not have missed seeing the deceased crossing the road. Under these circumstances, the driver of the Eicher Canter number so and so alone was liable for causing the accident. Hence, the jurisdictional police have filed charge sheet under 279 304A.
Yes.
So and so minutes. Your Lordship may kindly minutes peruse for a moment the sketch itself, minutes, which indicates that he was minutes crossing, which has two roads, minutes. He was in the center median lane. Near the center median lane, he had not crossed the entire road. The exhibit, minutes,
it is like you are coming from the right side.
Yes, minutes.
He is crossing the road like this.
Yes, minutes.
And the accident happened when he almost reached the
center median lane. Center median lane. He was not on the edge of the road. Exhibit P5 minutes is the sketch.
Give it.
P5.
Exhibit P5. How? What I just read, my lords, is not the correct position, my lords. What is indicated in the my lords judgment, the reasoning.
No, let's see.
Yes, my lords, yes.
Please tell me where is the accident is between A and B.
My lords, accident spot is A, my lords.
No, that black spot.
Black spot is the my lords. Yes, that is the
accident.
But this
you are coming from F to A.
But he is going from my lords this E to A, my lords. E to A.
E to A.
E
no,
to A,
you are coming
the
from
arrow
F
mark
to.
is not shown. Arrow mark is shown.
You are coming from F.
I am coming from F. Yes, I am coming from F. But this is
So
B, my lords,
he's-
is the B, my lord.
He's just about to reach the other side of the road.
No, my lords, it is not other side. It is the center of the road, my lords. The other side is this, my lords. Other side, they have not marked it, my lords. This is, B is not center median lane, which divides the both
Correct.
roads.
Correct.
But if he has to reach other side, my lords, it is the other side, my lords, which is 40 feet again, my lords. He is crossing this, he wants to cross this median lane and go to the other side. Therefore, my lords, it is at the center of the road, my lords.
It's a highway.
It is,
No,
my lords, within the city.
It is
my lords.
not an highway.
It is within the
It is
city.
City.
Yes, my lords.
Yes.
On this, my lords, may I rely, my lords, on one judgment of my lords, our own High Court, Division Bench judgment, my lords. Your lords may kindly take, my lords, parallel line 10, 11, 12, 13, my lords.
10, 11.
My lords, 10 is the discussion, my lord, the factum of the accident and injuries sustained by the claimant is not in very serious dispute. The controversy is in as much as the negligence aspect determined by the tribunal and the quantum. The tribunal analyzing the evidence has arrived at a conclusion that the accident in question took place when the claimant was crossing the road, but not at a junction as stated by the claimant. It has been observed that the oral evidence of the claimant is not fully supported by corroborated documents.
No, this is within the city.
Yes, within the city. Yes, my lords.
And near the bus stop, is it a case?
Yes, it is near the bus stop. It is near the bus stop. On the other hand, the records would reveal that the claimant, being a pedestrian, intended to cross the road at a place not designated for crossing. At that time, the alleged accident took place. It is the duty of the pedestrian to use the road with due care and caution, particularly.
Driver was examined.
Please not.
Driver was examined.
Not examined, my lords. They, my lords, in the complaint also it is stated, my lords, he was crossing the road.
Please, you
Yes.
have to examine the driver and elicit from him that suddenly he has crossed the road.
Yes.
That's why there was no occasion for him to look at it. So without even examining him, how do you expect to say that about contributory negligence just because he is crossing the road?
May I request this?
Yes.
The person, my lords, who is also, my lords, crossing the road should also be, my lords, careful, my lords. But what is the degree of, my lords?
No, it is.
What is
I
the
can
degree of care and
understand.
caution is
I
important.
can understand.
Yes,
It is a highway.
Yes.
It is a highway that he is crossing. That's not. He is crossing the road at the bus stand from this side to reach the other side.
Yes.
What is that vehicle?
Yeah,
Canter.
Eicher vehicle. It's a mini lorry, man, kind of.
So bus stop, there would be generally a lot of people.
Yes.
And all. Not that he is going on that road with a high speed of 60, 100 or so. So when the person has reached that place, that means this person he was about to reach the middle of the road, the other side of the road.
No, man. There are
Understand that in between.
He is at the, my lords, center of the, my lords, not center, my lords, median.
Generally, no,
One more median is there, my
unless-
lords. So, my
unless
lords,
un-
is therefore, your lordship, if you lordship observe, my lords, probably if bus is standing, my lords, he has to take, my lords, from here. My lords, if the bus is standing, if he has not suddenly come, he won't be able to, my lords, have a clear look whether, my lords, a person is coming
that
or
we
not.
can understand if you're showing it in the reverse direction. No, he's going this direction.
Yes.
So the same thing will not apply. If we can, your whatever your version that you're trying to put forth.
Yes.
If the person is coming from that direction to this direction, and if he is coming, then
Yes.
you can say suddenly he has crossed
Yes,
the road.
ma'am.
I have not seen.
Yes, ma'am.
He's already leaving. He's just like in another 1 feet he'll be going to the other side. That is the middle of the road at least. That yes.
But may I
Yes,
read this, my lords, so
Yes.
that, it is the duty of the pedestrian to use the road with due care and caution, particularly while crossing the road, and to look after for oncoming traffic. The degree of negligence has to be evaluated, fixing the contributory negligence 20%
This proposition there
for
is
the
no
purpose of determining the compensation.
on this proposition there is no dispute on that. It all has to be applied to the facts and
But
circumstances.
I really understand that, my lords, but my lords, here is a person, my lords, there is no, my lords, zebra crossing. There is also median, my lords. He has to, my lords, it is not that, my lords, he has some lane is put up, my lords, where they have to wait, or when no vehicle is coming, they can cross. But there is a median, my lords, center lane median. Therefore, my lords, certain degree of, my lords, negligence has to be, my lords, taken is my lords, submission.
My lord, the fundamental cause for the accident is the offending vehicle. The offending vehicle is coming from B track and suddenly took the turn to A track. Therefore, as per the sketch exhibit P5, my lord, the fundamental cause for the accident is the offending vehicle. My lord, F2A, my lord, is almost coming in the B track and suddenly he has taken right turn and coming to extreme to A track. Therefore, the fundamental cause for the accident is on the offending vehicle driver.
Please come.
My lord, in the
Paragraph,
previous,
may I read the next paragraph so that it is similar to this.
Yes.
The evidence on record would disclose that the spot of the accident was next to the road median. The claimant has admitted in the cross-examination that she has seen the offending vehicle
Yes, now
coming.
first,
Despite, please, madam.
the claimant has admitted that
Yes.
offending vehicle.
Yes.
So how this is different from this case? It starts with this.
Yes, ma'am.
Yes.
I understand that, ma'am. All the more, so the driver of the vehicle ought to have been more prudent and circumspect while driving, but it cannot be lost sight of the fact that a duty is also cast on a pedestrian and should use due care and caution in going upon a crossing the road, and it is the duty of the pedestrian to look out for oncoming traffic. It is needless to say that the pedestrian has to give the driver of a vehicle a plenty of time to see and slow down and start before attempting to cross or put one foot on the crossing. Moreover, whenever a pedestrian is crossing on a roadway at any place other than which is meant for pedestrian crossing, no claim can be made on any specific precedence and the responsibility for causing the accident more than not while will have to be shared by the pedestrian along with the vehicle driver. In view of this, it cannot be said that it was only the driver of the vehicle in question who was solely responsible for the accident. It has also to be noted that there is no evidence forthcoming to show that it was the pedestrian crossing. In view of the fact the claimant had crossed the road where she was not supposed to cross, certain degree of contributory negligence will have to be attributed to her. That's para 13. As aforesaid, it is bounded duty of the pedestrian to look out for the oncoming traffic from all directions before crossing the road where there was no designated crossing, zebra crossing for the pedestrians. Pedestrians cannot cross the road at their convenience, more particularly when the flow of traffic is high. Hence, we are of the considered view that it would be appropriate to fix contributory negligence at 30% on the part of the injured one. This is how the courts have that there was no designated zebra crossing, and he did not wait so for the, and there was traffic flow.
You are coming from lane 2, you have completely you take a curve like this.
Yes, ma'am. We have taken the sketch shows so.
Yes.
Ma'am, the second
So in
point.
these circumstances, we can't say that there is contributory negligence on the part of the client.
The second point is that the deduction is made at 1/4. According to me,
I think on that day when you were arguing on this point, I was not convinced. For the other point, you were waiting for him.
Yes, ma'am.
So what is the calculation?
Third point is that one more point is that
No calculation, you are saying something.
Your lordship did not make any calculation. It was
No, I'm saying I will calculate now. Yes.
Not calculate.
Which year is the accident?
It is 2018.
2018. And salary was taken as?
Notional income is taken at 12,500. Rightly
correct.
taken.
Age?
Age is age I am disputing. They have taken 35. 35 and multiplier of 16 is applied. I am saying he was in the G tree, what is it, family tree. His age is shown as 50 years. 50.
Why we will look at genealogical tree for a determination of age? There would be some other documents.
Yes,
they have not produced the Aadhaar card or election card of the deceased.
What is the age of the claimants?
Exhibit P8, madam. Postmortem report.
Postmortem, relying on the postmortem report.
That is sufficient.
I will submit. The
PM report, how much it is?
35 it is mentioned. 35. But in the chief examination, the PW1 says he was aged about 36 years. It is their own statement. It is not my statement. It is their statement that he was aged about 36 years.
That's a son.
No, the wife.
Wife says husband is 36 years.
36 years. So, the multiplier will change to 15 instead of 16. And they have produced the documents of rest of all the 1 to 4, but they have not produced the document of the deceased, which would indicate the correct age. But therefore, there is suppression of the documents.
No, but when there is no document on record with regard to the age, Then court has to generally take into consideration what is mentioned in the
But there is a
postmortem.
G3 months, which is again not their own document. It says 50 years.
We will take postmortem certificate.
But
And
postmortem, why it
if
cannot be more?
postmortem is taken,
Yes,
the calculation, there won't be any alteration.
there will not be any alteration.
And then what is the other ground?
But the PW1 herself submits that at the, I submit that at the time of death, my husband was 36 years old. They only say minutes in their own chief
No.
examination.
The wife's age is 26 years. How can the husband's age?
It
be
is shown
50?
as 50 years minutes in the G3. 36 minutes may be minutes correct age, because in view of the fact that all rest of the documents are produced of all the 4 claimants, his own document is not produced. Therefore, minutes, some suppression is there, minutes. They would certainly have their document. Minutes. If they produce minutes, we'll come to know the correct age. Therefore, minutes, 36 should be taken.
No, in those cases, wherever there is no other evidence, we are
Yes.
taking postmortem. That's a settled law.
Please.
You must please come. Agreed with order passed about passed in
But
everything.
with regard to deduction, but the second wife is also minutes, one of the claimant. Minutes, I was saying, my submission is this much. She is not a dependent because all the
Because you were relying on his
yes,
judgment.
yes.
I am relying two
Now I
judgments.
remember.
All the documents,
Take
my
that.
lords, all the documents which are produced are after the death, my lords. Whatever they have produced,
But wife has accepted.
yes, my lords, yes.
Here. I am relying two judgments. The first judgment is the division bench of this honorable court, and another judgment of the apex court.
Let's see the apex court judgment first.
Please, my lord, in para 21, my lord. I folded the page. Para 21, my lord. In this case, even my lord, mother-in-law as considered as the dependent. May I read, my
Mother-in-law is considered as a dependent.
dependent in this case? In the reported judgment. But in our own high court judgment, my lord, similar fact and circumstances of the present case, it was considered second wife and children are the dependents.
This ratio may not be applicable.
Yes.
So you are relying for the, as far as this is concerned, with regard to mother-in-law.
Mother-in-law,
Then next-
second authority. my lord.
Hmm.
Kindly see para number 22, my lord, page number 28. In this case, my lord, the claimants are the first wife, second wife, and her children. In my case also, the claimants are the first wife, second wife, and para number 22, my lord, page number 28. May I read?
What is the judgment in Jayashree's case?
Jayashree case, my lord, with regard to mother-in-law,
So that one.
please.
Mother-in-law, yes.
Mother-in-law.
It relates
That
to
one.
mother-in-law.
Mother-in-law.
What do you say then?
My submission is this, the,
No, in this case, no, a division bench of this court says
yes,
that all, how many wives they are all dependents.
that may not be the correct
But
proportion of
have you
law.
questioned this order, insurance company?
And here, the facts are that, my lords, all the documents for the second wife is, my lords, after the death. That is admitted in the cross-examination also.
But the wife says that
Yes.
she is my husband's second wife.
But that may not be permissible in law. Therefore, my lords, children, my lords, I am not, my lords, coming in the way.
This judgment
One
is
third will be
coming
the
in your
deduction,
way.
my lords.
The judgment is coming in your way.
So I leave it to your lordship.
Agreed with the orders passed on embassy number 601 of 2018, dated 13th July 2022. Whereby the court had granted compensation of an amount of rupees 27,10,000. The insurance company is before this court. The insurance company is assigning the award on the following grounds. Number one, there is a contributory negligence on the part of the deceased. Number two, the second wife cannot be considered as a dependent.
And my lords, one more, my lords, my lords. In the G3, my lords, the second wife name is shown as my lords, sister. It is not, my lords, in the family tree, which is also a government document issued. It is shown as sister, not wife.
With regard to the age, as per the genealogical tree, the age of the deceased is 50
years, 50.
years. And as per the postmortem, it is shown as 35 years and court has taken 35, which is not correct. Next to submission, in the genealogical tree, the second wife is shown as a sister, but not as the wife. Wife, and even even on that count, she cannot be considered. Next part. Learned counsel for the insurance company submits that the claimant had crossed the road, the deceased has crossed the road where there was no zebra crossing, and the accident has happened near to while he was reaching the middle of the road. It is submitted that there is negligence, contributory negligence, and the court has failed to consider. He had relied on the judgment, division bench judgment of this court in MS Leelambika and the Bangalore Metropolitan Transport Corporation and others arising out of MFA 5546 of 2018, clubbed with MFA number 6146 of 2018, dated 25th November 2020. He submits, he relied on paragraph number 11 and 12. Relying on this judgment, he submits that there is contributory negligence. Then, coming to the aspect of the age, he submits that the genealogical tree shows that he is 50 years old, and the court, when they have placed all the documents pertaining to the other claimants, why they have not placed the document pertaining to the deceased, shows that there is something fishy in that. And the court ought to have taken taken the age as 50 years. He further submits that the second wife cannot be a dependent, and all the documents that are filed to show that she is the second wife are all subsequent to the death of the deceased. It is submitted even those documents do not inspire confidence in the mind of the court, cannot inspire confidence in the mind of the court. And further, a second wife is not entitled for any, she cannot be treated as a dependent. Next paragraph. Land counsel, appearing for the respondent, claimant submits that the sketch, that is exhibit
P5.
P5 clearly shows that while he was starting from the left side of the road, he has come to the extreme right side of the road and hit the deceased. Clearly shows that it's a clear case of negligence on the part of the deceased, and on the part of the deceased, on the part of the driver of the offending vehicle. And the court had rightly held that there is no contributory negligence. He submits that when there are no documents with regard to the age, only the postmortem certificate has to be considered. And as per that, he is 35 years old. And even on that count also, there is no interference is called for. Then, with regard to the dependency of the deceased, he had relied on the judgment of the division bench judgment of this court in case of the managing director of Bangalore Metropolitan Transport Corporation versus Srimati P. Shanti and others, arising out of miscellaneous first of MFA number 7749 of 2016, dated 7 September 2022, and submits that even the second wife is entitled. He relied on paragraph number
21.
Paragraph number 21 and 22. Please extract. Basing on that, he submits that the second wife can be treated as a dependent in the light of the division bench judgment expert, having heard the counsels on either side. There is the material on record. First, coming to the aspect of contributory negligence, this court has perused exhibit P5. The accident had taken place near where the opposite to the bus stand, and even the map, the sketch shows that from the extreme left side of the road, the offending vehicle have gone to the right side and hit the deceased, who is about, who has completely, who has crossed 95% of the road. In the judgment that is relied on by the counsel for the petitioner, the division bench judgment, there is no dispute with regard to the said proposition. However, the judgments have to be applied to the facts and circumstances of each case, and the said judgment do not apply to the facts of the case, where in the said judgment, the claimant has admitted that she has seen the vehicle that is coming from she has noticed the opposite vehicle. In the considered opinion of the court, there is no contributory negligence on the part of the deceased. Then coming to the age, the court had rightly considered the postmortem, the age that is mentioned in the postmortem certificate, as there are no other evidence. And for the purpose of age, the court cannot look at the genealogical tree. Then coming to the dependency of the wife, in the light of the division bench judgment in so and so, even the wife has to be considered, second wife has to be considered as a dependent. In view of the above discussion, this court do not find any reasons to interfere, and accordingly, appeal of the claim insurance company is dismissed. The amount in deposit shall be forthwith transferred to the.
There is already a pay and recover order, my lords.
The court has, there is already a pay and recover order. The insurance company shall pay and recover. The amount in deposit shall be forthwith transferred. Yes, next 31. What is this case?
These are the dispute is with regard to only quantum.
Seeking enhancement and also.
Oh, there are so many.
We are on quantum.
You are on
quantum.
So as far as this case is concerned, you have not.
One case we have not appealed. All the other cases we
So
have.
this we will decide first. Take that. Somebody has to take the papers. Where is the?
She's writing.
3614 of 22 and 8167 of 22 arising out of MFS MECs are 4.
1 minute.
4122.
8167 of 22 is arising out of
4122 of 2017.
In order, I'll given that list.
It is there. He has given it. Is arising out of
4122 of 2007.
4122.
And the company appeal is 3614 of 22.
Okay. So now we will take up 8167. In that there is an appeal of the company, that is 3614. That is, which is the serial number? 3614.
The date of accident is 3/11/2016.
No, 1 minute. I don't find this 3614.
Is there?
Serial number 3614 is serial number.
31 only.
That is 31.4. So 31.4. Yes.
The injured was aged around 22 years and was a student.
1 minute. That is not required. Only we'll have one. 8167. Please come to the table. There are so many MVCs.
Yes.
So we are on 4122.
5 MECs are.
4122.
The table is at page number 30 of the judgment. The accident has occurred on 3/11/2016.
In paragraph number 64.
Yes, my lord.
Paragraph 64. Yes. Pain and suffering 1 lakh is granted.
I'll just brief the injuries, my lord. Splenic rupture, fracture of L2, L3 and L4, fracture of 3rd and 4th ribs. The doctor has assessed 28% whole body disability and court has fixed 30% disability.
Court has taken?
30. And the compensation is awarded, your lordship kindly see, the main ground on which the insurance company has appealed is loss of marriage prospect to an extent of 1 lakh. Loss of marriage prospects is granted at rupees 1 lakh. Plus she was married during 2019, during the pendency of the petition itself.
No, it is not that she'll not be getting married. Issue is, she wouldn't be getting a match which she deserves, and also it would have some impact on her life.
It is not their case also. It is not their case that she may not get married to a,
No, generally.
whatever it is.
Generally, that is as on the day when the accident had taken place, she's unmarried.
She was, subsequently she has married during the pendency itself, my lord.
Is it the compensation is granted that they will never get married?
No. It is not that. My lord, if they should have admitted, they have not admitted that she is married during the pendency of the petition. The inquiry by the insurance company and the social media status says she is married in 2019 itself. So this is one. And apart from that, the future medical expenses that is granted at 1 lakh, that is also on the higher side.
What is how many operations he has to undergo?
He has undergone around 2-3 operations.
No, like what we are doing for, this is a year of 20, accident is of the year 2017.
2016.
She undergone splenectomy.
At least 20,000 we grant for one operation. So if they have to be 3 operations.
60,000.
60,000.
She undergone splenectomy. Splenectomy. Lot of immunity power will be reduced.
No, my lord, splenectomy
She will
has been
develop
done.
a lot of diseases
Now,
in future
Your Lordship may kindly see,
because of
the court
splenectomy.
ignores the evidence of the PW14.
What did the doctor say about the operations? How much it costs?
He has not stated anything, my lord. The evidence with regard to doctor is PW14. PW14 doesn't state anything about the future medical expenses. Now I have the affidavit copy. He says, now he assesses the disability to an extent of 28%, out of which locomotor disability is 10%, disfigurement disability is 18%. He doesn't say, no, Your Lordship, can you see, what is splenectomy? Spleen is a place where the blood gets purified. There are instances people leave. Yeah, I have an instance, one of my cousin, he is a practicing doctor. He, in the year 98, his spleen was removed because of some rupture. He is perfectly normal, and the doctor has not stated anything about that. The court presumes, Your Lordship may kindly see the order of the court. The court presumes, based on the literature, and comes to the conclusion that there would be a lot of complications. That is not so by the doctor. Well, if at all, if she had to undergo certain complications, the doctor should have said so. The doctor has not said anything about that. The court relies upon.
When the doctor says 28% is disability, why should the court take 30% as a disability?
No, my lord, apart from that, the 18% disability is only with regard to disfigurement. It is not the disability has got to do anything with
She's
the
having a
physical.
lot of scars all over the body.
So for that, there should be a different compensation. That you can't include it in a
Lord,
whole body disability.
For this splenectomy, no, the general surgeon is not examined. I have furnished literature only for that purpose. I furnished the literature in my written argument. In search researchers, it is discloses a lot of difficulties.
It is not
because
for
of the
this court.
splenectomy.
It is for the trial court. While granting such an amount, there should be some discussion on that. That whatever literature you are placing before the court, the literature the court should have known. Trial court.
General surgeon, because of non-availability, I am not examined. But
No,
splenectomy,
please come to this.
it affects
Pain and suffering. I think with all the injuries, it's 1 lakh is nothing.
1 lakh, I am not touching on that.
Then medical expenses you are not disputing.
No, madam.
Then food, nourishment. How many days he was there in hospital?
She was in hospital.
12 days. Totally 12 days. 11 days.
11,000 is, it is correct. Next, loss of amenities in life, loss of future earning capacity. This you are disputing.
The
So
income is
what is the
considered
income taken?
12,000.
12,000. She's a
12.
7th semester B student.
12,000. Then according to the doctor, what is the limb disability?
It is this is a plastic surgeon. Total disability assessed is 28%.
28%.
But regarding splenectomy, no disability is assessed. That is to be assessed by the court.
What I'm saying here, When we decide this, what is this the loss of future earning capacity, it has to be based on the incapacity or your disability of a particular claimant. What is the impact of it on the future life? All scars and other things, these are all cosmetic issues. Cosmetic issues, for that we will give a different compensation for that. But when you have to apply the multiplier for the cosmetic issues, we cannot grant the.
But my lord.
No, will it have, for example, disfigurement? Will it have an impact on your future earning? If you're doing a particular job.
Appearance itself is looking bad.
Correct, for that.
Facial injuries also
That
there.
cannot be, there can't be a multiplier for that. That's what I'm saying. There can't be a multiplier for disfigurement. Multiplier is only loss of future earning capacity because of the disability you have sustained. What is that kind of a disability?
But in respect of splenectomy is concerned, my lord, that is why a tribunal assessed a higher amount of disability. Splenectomy, it affects.
It can do it, but
immune,
it has to
it
be.
affects immune power. It virtually it affects on earning capacity also.
No, that may be, no, my lord.
She
My lord,
cannot.
I keep, it is my nephew, he is an ophthalmologist. He underwent the splenectomy in the year 98.
Assumptions, those are all assumptions.
No,
It is a general principle. I don't say that.
I'll set aside this award and send it back to the court again, because it can't be how can the court say that loss of future earning for a disfigurement? And it can't take it 30% to 20%, how much it is taken, 28% or 30%? Whole body, how can it be? It will not come in the way of your income.
Definitely it affects me a lot. Because of splenectomy, she immune
I'll
power
remind
is
this
will be-
matter. Please. Agreed with award.
Let all the matters, anyway, the common judgment, my lord. Let all the matters get remanded. We will see to that in the court.
Lord, disability aspect, my lord, only 30%.
Only this is remaining or not these kind of issues?
In next case also 4123 is also.
This is also with regard, no, that is with regard to fracture of humerus and fracture of ribs. Court has, the doctor has stated 17.33% disability, whereas the court has considered 20% disability. And here also the income is considered at 12,000.
Only 12,000.
And the subsequent information what we have received is she is employed in USA. She is gainfully employed in USA, whereas the court grants 5,18,400 towards loss of future earning capacity.
Remand all the matters.
May be considered here, and my lord, because the disability, what is considered, my lord.
No, my lord,
it is not a case where 100% disability is considered.
No, why I am saying is, first matter, the case which is argued now, I'm really not convinced with it. Compensation can't be in that way. You can't assume and presume something unless and until there is for that you have to have the evidence of the doctor.
Or else globally, if he agrees for some reduction in the global compensation, it can be done and it can be finalized here.
In that case, we will do. Then both of you, then.
No, he should agree, madam.
If there is a chance, I'll examine the general surgeon regarding splenectomy. What is the disability will be there? I will have a
That's what. Considering the interest of the.
Yes, ma'am.
Yes.
In 6294 also, it's a damages case.
6294 is a?
Damages to property. The vehicle straight away driven into the.
So this need not go.
No, but here also the damages is under challenge. Court has granted 3,30,000 rupees towards the damages and 1,82,880 towards the repairs of the electric items and 57,000 rupees towards loss of income. This is under challenge.
The entire shop is damaged, my lord. I assessed the contractor also, who is raised the bill. Agreement is also produced.
Yes.
The vehicle driven into the
why
shop.
This cannot be decided? 6222.
Be decided, here.
What we do is 6294 will keep it here, and remaining other matters we will remand it.
6295 is the injury claim, my lord. Is suffering during injuries and also.
That we are not in appeal. 6295 we have not filed.
You're not in appeal.
We are not challenged.
Then we will decide that.
Please, ma'am.
So 6295 we can
And
decide.
even 6296 also it can be decided.
Because
so what can be remanded is 4122 and 4123.
4123.
4123 and 6294.
6294 is
No, 6294 is vehicle damage case.
Yes, not vehicle, property damage.
Property damage.
Property damage. So it has to go or can be here?
We can decide here only.
So
Via media, we have to decide.
4122, 4123, we will remand.
Please.
Agreed with the orders passed in MVC number 4122 of 2007, 4123 of 2017, dated 10th November 2021. The claimant has filed 8167 of 2022 and 8188 of 2022, and the insurance company has preferred MFA number 3614 of 2022 and MFA number 3548 of 2022. The learned counsel appearing for the insurance company submits that the court has granted exorbitant amounts as compensation without even considering without considering the evidence on record. When the disability in MVC number 4122 of 2017 is only disfigurement, court had considered the loss of amenities, loss of future earning capacity. Land counsel appearing for the claimant submits that she had to undergo, what is that, splenectomy.
She undergone.
She has already undergone.
She has undergone splenectomy, and it would have a lot of complications in the life, considering that the court had granted. What is the impact of that surgery on the claimant? No doubt, no doctor is examined in that behalf. Even in the other MVC also, that is 4123 of 2007.
She undergone laparoscopy.
17. The insurance company is also coming up with these kind of objections with regard to the amount that is granted and the non-examining and that the claimants have not examined the doctors. The court had granted exorbitant amount.
4123, my lord, pancreatectomy.
In 4123, pancreatectomy. In considering all this court deems it appropriate to set aside the award in MVC 4122 of 2017 and 4123 of 2017 and remand the matters to the trial court, to the tribunal for fresh consideration. Accordingly, the court is passing the following order. The award dated so-and-so, passed by so-and-so in MVC number 4122 of 2017 and 4123 of 2017 is set aside. And both the cases are remanded back to the court for fresh consideration. The amount in deposit shall be forthwith transferred to the trial court.
The 50% amount is been withdrawn, my lord.
Withdrawn. Whatever is, it is already withdrawn.
Yes, sir. In these two cases, they have withdrawn 50%.
So nothing is here to transfer.
No, 25,000 statutory deposit is still pending here. That may be transferred.
The amount in deposit shall be transferred to the court. And accordingly, MVC 3614 of 2022, 3548 of 2022, and MFA 3614, 3548, 8167, 8188 are allowed. Yes. Then let's go to the next matter, 6294.
94.
6294.
That this is pertaining to the damages to the shop.
Yes.
That here, the petitioners claim that they have
MFA 8169.
MFA
8169 and
8169 and 3649.
One is sufficient. Yes.
That it starts at para number 114 of the judgment, page number 51.
114.
114, page number 51 of the judgment.
Yes.
Let the PW8 in his chief examination has, PW8 is the claimant. Suppose that
Paragraph number?
114 at page number 51.
114 is 51, yes.
PW8 in his chief examination has deposed that he has repaired a shop for 6,55,000 rupees to the petitioner. He further deposed that he has received 3,30,000 rupees from the petitioner and he has agreed to receive the balance of 324 after receipt of the compensation amount. During the course of the cross-examination of PW5 and 8, the genuinity of exhibit P50, 55 and 56 are challenged. During the course of the cross-examination of PW8, he has clearly stated he has only executed the civil work and further admitted that there is no damage to the brick wall. Considering the admission of exhibit given by PW8 during the course of the cross-examination and 52 exhibit P52, 7 photographs, there are no major damages to the structure. Therefore, the petitioner is not entitled for the compensation as estimated at exhibit P55 to towards the POP interiors and exteriors. Considering the damages caused to the interior and the POP work and the damage caused to the electrical goods, which the petitioner has to redo, other things, a compensation of rupees 3,30,000 awarded the petitioner towards the damages caused to the Goli Vada Pav shop. As per PW8 has clearly deposed that he has already received 3,30,000 rupees in advance for 3,25,000 rupees the balance. Now coming to that, my lord.
So their claim is rejected.
Yes. The 3,30,000 rupees is granted. The additional 3,25,000 rupees what they claim that they will pay it after the receipt of the compensation is rejected.
And you are on what ground that they are not even entitled
Next
for?
ground, my lord. 1,82,800. See, there is no evidence with regard to this. They have only produced the document in support of the damages. Whether they have really incurred 1,82,000 rupees, 82,000, and from where did they purchase the electrical items which were damaged, and what has happened to the electrical items which was damaged, whether they have sold it or recovered some amount, no evidence is forthcoming. The court presumes and accept the evidence of
No, when you say 1,82,000 for purchasing those goods, anybody is examined? Nothing is shown before the
so
court.
far as this,
Only bills
no
are
witness is examined.
I am not examined. The bills I have produced, my lord. The vehicle straight away driven into the Vada Pav shops, my lord. Entire interiors were damaged. Not the, there is no civil damages, but entire interior is damaged. Oil, which is installed there for preparing fries, it is spilled on the another petitioner on
I can
Mallesh.
understand, but for granting
Oil spills
compensation,
there.
there should be some material before the court. Some evidence should be there. Somebody
But
must have been.
photographs only discloses that that oil is boiled oil is spilled all over the shop, and also on the petitioner in.
They have purchased the electrical items which was damaged. They should be specific saying that which are all got damaged and what has happened to the.
I produced.
they
I
have
examined the contractor also who is.
No, what has happened to the salvage? They could have, they have recovered, they would have definitely recovered some amount due from
everything
the
is
salvage.
burned out because of
Nothing
the
is
oil
forthcoming.
spills.
And the court blindly
In
believes
Mazar it is
the
explained.
evidence of PW8 and grants compensation to an extent of 1,80,000.
In Mazar it is explained about the damages.
No, I am
Damages to
not
the
denying for the damages, but how did the 1,82,000 rupees is granted? That is the only question.
That's what both of you, because negotiate something and will grant some lump sum amount.
Well, this can be called next week. In the meantime, we'll have a discussion with the
Even
insurance
about the other matters also.
Let the other matters, I don't think so, my learned friend will.
In next case, my lord, only 25,000 global.
Other matter can be
This
disposed
matter
of.
next week. This is matter next week, only this one. Yes. What about 6295?
6295 is
I mean 8137.
8137.
295, I am not in appeal.
What about this? What do you want in 8137?
Enhancement, my lord, 25,000 global compensation is granted.
What are the injuries?
It's a grievous injury case, my lord. And also there is a vehicle damage, 45,000 bills are produced, but only 25,000.
Vehicle damage, or it's a case of
In this case, he's traveling on two-wheeler. By that time,
no,
accident is
for
taken.
the injuries you wanted
Injury
compensation.
and vehicle damages.
See 8137, where is the page number?
Page number 54, para number 121, man.
121, 6295. Compensation of 5 lakhs from the respondent.
See, including for
Including 45,499 towards
that
vehicle
is,
repair charges.
The 45,499 towards vehicle repair charges. That is the all considering all these things. Only 25,000 globally.
The petitioner has relied on his own oral evidence as PW3.
128 would be, para number 12508 would be very relevant.
From going through exhibit P34, it is clear that the accident, the petitioner has sustained cut, lacerated wound and abrasion. And both the
In this, he has declared the value of the vehicle for 15,000 rupees.
No. First time on the injuries.
Please.
Cut, lacerated wound and abrasion. Both are injuries described as grievous in nature.
Deep cuts are there. Deep cuts are there because of that. He spent around 4,000.
Except P34 and 36, the petitioner has not produced any other medical records as an outpatient, and he has purchased medicines.
Next paragraph, damage.
Then where is your vehicle damage?
Vehicle damage in para number 120.
Para number 127 and 128. 128 would be relevant. The petitioner has also relied upon Exhibit 40, invoice of the labor bill issued by Bridgestone Service and for having repaired the vehicle. The learned advocate for the respondent number 2 vehemently argued that Exhibit 42 is the insurance policy of the two-wheeler. It is clear that at the time of insuring the vehicle, the petitioner himself has declared the IDV value of the vehicle at 15,000 rupees. Therefore, 15,000 rupees is granted.
But he spent around 44,000.
Vehicle value itself was 15,000 rupees as on the day of the. It is
Because
his statement.
vehicle is spent for repairing the vehicle.
My lord, I concede another 10,000 rupees will be.
The payments are towards injuries only 25,000 global.
Simple
For previous injuries.
No doctor, nothing.
Doctor is not examined
No,
only
no, no,
because
no. When you
these
say
deep laceration wounds.
on the face of it, those injuries appears to be simple injuries. Somebody said it
Not
is a
simple,
grievous
not
injury. He should be examined for that.
Because of
Lacerated
this
wound, abrasion.
deep
Abrasion
abrasion.
is a grievous in nature.
Previous injury, but 25,000 is very much. Medical expenses around 4,000.
5,000.
And incidental expenses also will be there for him.
Another
Only
10,000 rupees. Another 10,000 globally.
10,000 globally for both or for each?
No, for both. On the whole, 10,000.
And vehicle and.
On the whole, 10,000.
Totally globally 1 lakh compensation is given.
The court will be setting a back.
Oh, no. You can't make those kind of requests. 10,000, that is also because he is voluntarily saying, I would have not done.
What should grant 25,000 at least? 25,000 additional compensation.
If it's ready, I'll grant. 10,000 is saying?
10,000 is very less, sir.
My fairness is over. It is left to
Yes.
you.
25,000 kindly be.
MVC number 6295, agreed with the award passed in MVC number 6295 of 2017. Dated 10th November 2021. The claimant is before this court. The claimant had sought for compensation of 37 lakhs 79 as sought for compensation of 5 lakhs.
8137.
What is this? 37 lakhs 79,000.
That is a mistake.
Has sought for compensation of rupees 5 lakhs. In that, he has sought for 45 lakhs 499 towards vehicle repair charges. According to the claimant, he has sustained injuries. In support of that, he has relied on Exhibit P34 to 36. P34 is a wound certificate. As per that, he had sustained cut, lacerated wound and abrasion on both the injuries are described as grievous in nature. And except that, no other documents are produced. Exhibit P6 is the medical bills, which shows that he has spent an amount of rupees 4,091. Court had granted compensation of global compensation of 25,000. When it comes to the vehicle damage, as per the IMV report, there are 7 damages to the vehicle. The petitioner, the claimant himself has declared the IDV value of the two-wheeler as rupees 15,000, and accordingly court had granted 15,000 as granted 15,000. So altogether 15,000 for the vehicle damage and 25,000 for the injuries.
Injuries.
25 and 15.
Totally 40,000. Totally 40,000. 15,000 towards damages.
25,000 and 15,000, total 40,000 is granted. Now we'll be making it 50,000 globally. The learned counsel appearing for the petitioner for the appellant claimant submits that the court had failed to consider the value that the amount that spent by the claimant for the repair, for the damages, for getting repaired the damages to the vehicle, and it is also submitted that when the claimant had sustained grievous injuries, the court had granted 25,000, which is on the lower side. The granting compensation of 40,000 is not a just and reasonable compensation. Learned counsel appearing for the respondent insurance company submits that the court had rightly considered and granted, and in fact the compensation that is granted is on the higher side. Next para. Having heard the counsels on either side, there is a material non record. So the claimant has stated that he has sustained grievous injuries. Except the wound certificate, he has not placed any other. He has not examined anyone. And the court considering the injuries and the medical and the amount that is spent for the medicines granted 25,000. When the vehicle, the value of the vehicle according to the claimant himself is 15,000. The court, he has stated that he has spent 45,499. The court has refused to grant the same and granted 15,000. 15,000. Considering the injuries that are sustained and the damages that are damages to the vehicle, this court is inclined to grant an amount of rupees 50,000 globally on the two counts. Accordingly, the appeal of the claimant is partly allowed. Yes.
Let the next matter.
Then what about the next one?
6296.
3550 of 22, 8136.
8136. Take out that 8136. What about this?
Let in this, the
This oil which is boiling is spills on him.
The accident is of the year 2016.
Please
The
come
court
to
has
that.
considered
Which paragraph?
That the table is at para number 147, page number 64.
147.
Let the accident is of the year 2016. He is cooked by a profession. No document is placed on record to establish that his income was 15,000 rupees. Court has considered 12,500. 2016, as per the chart, it should be 9,500.
Petitioner in
No, you lost my kindly see.
petitioner in 6295 Krishna Nadi, that damages to property. He is the employer of the petitioner. He is also stated in the position.
No, we'll go by this.
PW
Pain and suffering 40,000. How many are the injuries?
He has suffered
one grievous injury.
Lord, your lordship may kindly refer to photographs which I produced at.
Yes, sustained permanent on account of.
He has suffered considering the burn injuries, my lord. He has not suffered any fracture.
Burn injury, what is the percentage?
The doctor,
15% disabilities.
PW11 is the doctor. He has stated 10% physical impairment due to burn injuries. 10%.
Total 15%.
What do you say on pain and suffering?
Well, at pain and suffering, I am not on that pain and suffering. I am only on.
Lordship may kindly be referred to photographs. Which
Anything to be enhanced, I am saying.
No, my lord, 40,000 is reasonable. I am on.
My lord, your lordship may kindly consider photographs I produced.
Future medical expenses is granted at 2 lakhs.
50% of the burn injuries.
10%, my lord. 10%.
It says 50%. We'll take up this matter on next Thursday. Keep it on next Thursday.
The LCR may kindly be.
A call for the TCR. TCR is already there. One more. There are so many. There are other matters. No, this is the last matter.
Yes, sir.
Yes, yes. Yes, yes.
2 matters remanded.
Yes, remaining matters on next Thursday.
That is
Remaining matters on next Thursday.
My lord, serial number 33, my lord, may I make one submission?
Serial number 26 is passed over, my lord.
My lord, serial number
20?
6 is passed over, my lord. Owner's appeal.
Next Thursday.
We'll have it next Thursday.
Obliged.
My lord, 36.
My lord, serial number 33, my lord.
In 36, there is an interim order which may be executed.
36, sir.
36, finally.
Huh?
36.
36 is 36. Wherever interim orders are there in all those matters.
Much obliged.
My lord, serial number 33, my lord, 4 weeks, my lord.
This also Thursday.
My lord, serial number 33, my lord, serial number 33.
We'll come next Thursday.
4 weeks required, my lord.
Why?
Okay, because translation may be necessary. Dismiss it
What
as
translation?
The case has been dismissed, my lord. Petition came to be
What
dismissed.
translation?
Mr. Shastri wants the translation to be filed.
Translation of what?
police document and evidence.
Whatever translation you read, I'll understand.
Yes.
Not tested.
Connected at 49. ಎಲ್ಲ ಕೊಟ್ಟಿದ್ದೀನಿ ಈಗ 4 ಕನೆಕ್ಟೆಡ್ 49
ಅದರಲ್ಲಿ ಒಂದು ಮೇನ್ ಫೈಲ್ ಮಾಡ್ಕೊಬಿಡಿ
ಒಂದು ಮೇನ್ ಫೈಲ್ ಮಾಡ್ಕೊಂಡು ಲಿಸ್ಟ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಆನ್ 49
8136 3550 ಆಮೇಲೆ 8169 3469 ಇಷ್ಟು 4 ಮ್ಯಾಟ್ರು ಅರ್ಜೆಂಟ್ ಆಗಿದೆ.
ಕನೆಕ್ಟ್ ಮಾಡಿ ಅರ್ಜೆಂಟ್ ಮಾಡೋಣ.
ಎಲ್ಲ 4 ಇವು 4 ಕನೆಕ್ಟ್ ಮಾಡ್ಬಿಡಿ. ಸರಿಯಾಗಿ ಬರ್ಕೊಂಡಿದ್ದೀರಾ ತಾನೆ?
3469 3550 8136 8169
4 ಮ್ಯಾಟ್ರನ್ನು
14.
ಇನ್ನು ಉಳಿದಿದ್ದ ಎಲ್ಲ ಮ್ಯಾಟರ್ಸ್ ಅಷ್ಟೇ ದಿಸ್ ಮ್ಯಾಟರ್ ಎಂಟ್ರಿ ಮಾಡಿ ನೋಡ್ಕೊಂಡು extended till next date of hearing. Serial number 26 also Thursday. Fast forward ಬರ್ಕೊಳ್ಳಿ. 36 serial number ಇನ್ನೊಂದು ಯಾವುದು? 3 ಅಂತ. ಇಲ್ಲ. Serial number 4. ಮತ್ತೆ 2. Serial number 2 ಇದೆ. Serial number 2 ಬರ್ಕೊಳಪ್ಪ. Serial number 2 and serial number 26. ಇನ್ನು ಉಳಿದಿದ್ದು ಎಂಟೈರ್
ಅದು ಕೂಡ 48.
ಅದು 14.
ಆಮೇಲೆ ಇದನ್ನು 48.
48. List this matter on 48 ಅಂತ ಹಾಕಿ. 2 26 ಆಯ್ತಾ? ಇನ್ನು ಉಳಿದಿದ್ದು ಹಂಗೆ ಎಲ್ಲ ಇದು ಕಟ್ಬಿಡೋಣ. ಇದು ಬುಕ್ ಕೊಟ್ಕೊಳ್ತೀವಿ. ಚೆಕ್ ಮಾಡ್ಕೊಳ್ಳಿ. ಜೊತೆಗೆ 8169 ನೆಕ್ಸ್ಟ್ ಕೆಮೆಫೆ 3469 ಜೊತೆಗೆ 698469 ಹೇಳಿದ್ದೀನಿ 8169 ಇದೆ 3469 ಜೊತೆಗೆ 8169 3550 ಜೊತೆಗೆ 3550 ಜೊತೆಗೆ ಕೆಮೆಫೆ 8136 ಆಯ್ತಾ? ಅಲ್ಲಿ ಗೊತ್ತಾಗ್ತದೆ MBC ನೋಡ್ಕೊಂಡು ಕನ್ಫ್ಯೂಷನ್ ಆಗ್ತದೆ. ಕರೆಕ್ಟ್ MBCಗೆ ಒಂದು MBC ಇಲ್ಲಿ 2 MBC ಒಂದು ಇನ್ಶೂರೆನ್ಸ್ ಒಂದು ಕ್ಲೈಮೇಟ್ 2 ಇದು 3469 ಅಂತ TCR ಕೆಪ್ಪಿಲ್ಲ ಮಾಡ್ಬಿಡ್ಲ ಬಿಂದು ಡಿಸ್ಪೋಸ್ ಆಗಿರೋದ್ರಲ್ಲಿ ಏನಕ್ಕೆ ಬೇಡ
ಸೀರಿಯಸ್ ಆಗಿ ತಗೋಬೇಕು.
connected with MFA.
Connected with MFA.
816 3469 MFA ಜೊತೆಗೆ
this matter on 14/8 connected with
connected
along with
ಮೇಲ್ಗಡೆ ನೀನು ಈ ತರ ಮಾಡ್ತೀಯಲ್ಲ ಇಲ್ಲಿ
ನಾನು
ಒಂದಿನ ಒಂದಿನ
ಇದು ಡಾಕ್ಯುಮೆಂಟ್ ಅಲ್ಲಿ ಬೇರೆದೆಲ್ಲ ಡೀಲಿಂಗ್ ಆಗಿರುತ್ತೆ. ಬೇರೆ ನಮ್ದು ಇವಾಗ ಆರ್ಡರ್ ಹೋಗಿ ನಾವೇ ತಗೊಂಡಿರ್ತೇವೆ. ಇವಾಗ ಇಲ್ಲಿ ಮೈನ್ ಮ್ಯಾಟರ್ 8167 ಇದು ಅಲೌಡ್ ಅಂಡ್ ರಿಮ್ಯಾಂಡೆಡ್ ಕನೆಕ್ಟೆಡ್ ಇದ್ದಿದ್ದು ಅದ್ ಮೈನ್ ಮ್ಯಾಟರ್ ಹೊರಟೋಯ್ತು ಮಾಡ್ಕೋಬೇಕು ನೀನೀಗ. ಅದನ್ನ ನಾನು ಹೇಳ್ತಾ ಇರೋದು 3469 ನ 8169 ಜೊತೆಗೆ 3550 8136 ಅಂಡ್ ಕನೆಕ್ಟೆಡ್ ಒಂದು ಕ್ಲೈಮೆಂಟ್ ಒಂದು ಇನ್ಶೂರೆನ್ಸ್ ಆ ತರ ಮಾಡ್ಬಿಟ್ಟು ಲಿಂಕ್ ಮಾಡಿ ಕಳಿಸ್ಬಿಡಿ. ಅಲ್ಲಿ ಲಿಂಕ್ ಇರುತ್ತೆ.
ನಂಗೆ ಲಿಂಕ್ ಮಾಡಕ್ಕೆ ಗೊತ್ತಿಲ್ಲ.
ಡಾಕ್ಯುಮೆಂಟ್ ರೆಡಿ ಮಾಡ್ಕೊಳ್ಳೋದು ಗೊತ್ತಿಲ್ಲ ಇದೆ. ಇವಾಗ ಮ್ಯಾಟರ್ಸ್ ಈಗ ಒಂದು 10 ಮ್ಯಾಟರ್ ಲಿಸ್ಟ್ ಆಗಿರುತ್ತೆ. 10 ಮ್ಯಾಟ್ರ್ 5 ಮ್ಯಾಟ್ರ್ ಡಿಸ್ಪೋಸ್ ಆಗ್ತದೆ 9 ಮ್ಯಾಟ್ರ್ ಕೊಡ್ಬಹುದಾ ಮೆಮೊ ಸೆಪರೇಟ್ ಆಗಿ ಮಾಡ್ಕೊಳ್ಳೋದು ಗೊತ್ತಿಲ್ವಾ ಅದು ಅದೇ ತರನೇ ಆಲ್ರೆಡಿ ಲಿಂಕ್ ಆಗಿದೆ ಇದೆ ಅವಾಗ ಮ್ಯಾಟ್ರ್ ಡಿಸ್ಪೋಸ್ ಆಗೋಯ್ತು ಇಟ್ ಇಸ್ ಆಲ್ರೆಡಿ ಲಿಂಕ್ಡ್ ಅಲ್ಲಿ ಇದೆ ಈಗ ಪೆಂಡಿಂಗ್ ಇದೆ
ಬೈ ಈ ಕಡೆಗೆ ನೋಡ್ರೆ
ಅವಾಗಲೇ ಏನಂತ ಹೇಳಿದ್ರು
ಕಂಪ್ಯೂಟರ್ ಬ್ಯಾಂಕ್ಸ್ ಅಲ್ಲ ನಿಮಗೆ ಕನೆಕ್ಷನ್
ಇಂದ ಬರ್ತೀರಾ ನಾವು ಹೊಟ್ಟೆ
ಯಾವುದು ಡಿಸ್ಪೋಸ್ ಆಗಿದೆ ಅದನ್ನ ಡೀಲಿಂಗ್ ಮಾಡ್ತಾರೆ ಮಾಡ್ತಾರೆ ನೋಡ್ಕೊಳ್ಳಿ ಆಮೇಲೆ ಅಲ್ಲಿ ಲಿಂಕ್ ಡಾಕೆಟ್ ಆನ್ ಮಾಡಿ ಡಿಸ್ಪೋಸ್ ಆಗಿದ್ದು ಈಗ ಪೆಂಡೆನ್ಸಿ ಯಾವ ರೆಕಾರ್ಡ್ ಇದೆ ಅಟೆಂಡೆಂಟ್ ಅದನ್ನ ಮಾಡ್ಕೊಂಡು
ಬಂದ ಅಣ್ತಮ್ಮ
ಅವಾಗಿಂದ
ಬಂದ
ಎಲ್ಲ ಮಾಡಿ ಅದನ್ನ ಅದಿದ್ರೆ ಅಕಸ್ಮಾತ್ ಡೀಲಿಂಗ್ ಮಾಡ್ಸ್ಬೇಕು ಹೇಳ್ಬೇಕು
ಬ್ಲಾಕ್ ನನಗೆ
ಇದೆಲ್ಲ ಸೀರಿಯಲ್ ಅಲ್ಲಿ ಇದೆ ಸದಾ ಸ್ವಲ್ಪ ಬುಕ್ಕಲ್ಲಿ ಸೈನ್ ಮಾಡಿಲ್ವಾ
ಬಾಸುಮತಿ ಅಕ್ಕಿ ಹಾಕಿ ಮಾಡಿರೋದು ಕೈ ಅಲ್ಲೇ ಕಳ್ಳ
ಗಂಗಣ್ಣಿಗೆ ಸಪೋರ್ಟ್ ಮಾಡೋದಂತ ಹೇಳಿರೋ
ನಿಮ್ಗೆ ಗೊತ್ತಾಗ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಅಲ್ಲಿ ಮಾಲಾ ಇರ್ತಾರೆ DR ಅವ್ರನ್ನ ಕೇಳಿ ಏನಾದ್ರು ಡೌಟ್ ಆದ್ರೆ ನಮ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಫೋನ್ ಮಾಡಿ ಆಯ್ತಾ
ಓ ಪಾಪ ಬೇಡ ಅಷ್ಟೊಂದು ಬೇಡ
ಹೇಳಕ್ಕೆ
ಟೈಮ್ ಬರ್ತದೆ
ನಿಮ್ಗೆ ಒಂದ್ಸಲಿ ಏನೋ ಕ್ಲಿಕ್ ಮಾಡ್ಕೊಂಡಾಗ ಹೋಯ್ತಾರೆ ಇಷ್ಟರಲ್ಲೇ ಕಳಿಸ್ತೀನಿ ನಮ್ಗೇನು ಅವಶ್ಯಕತೆ ಇಲ್ಲ ಅಂತ ನಾನು ಹೇಳಿದ್ರು ಅವ್ರು ಹೇಳೋದು ಈಗ ಹೇಳಿದ್ರು ನಮ್ಗೆ ರೇಟ್ಸಿಂದ ಒಂದು ಸ್ವಲ್ಪ ಮನಸ್ಸಲ್ಲಿ ಇರುತ್ತೆ ಅದು
ನೋಡ್ಲೇನಪ್ಪ ನೀನೇನ ನೋಡಿದ್ದಾರೇನಪ್ಪ
ಅವನಿಗೂ ಬರ್ತದೆ ಟೈಮ್ ಬರ್ತದೆ ನಂದು ರಿಟೈರ್ಡ್ ಆದ್ರೂ ಬಂದು ಹೇಳ್ಬಿಟ್ಟು ಹೋಯ್ತೀನಿ ಏ ಮಧು ನಾನು ರಿಟೈರ್ಡ್ ಆದ್ರೂ ನಿನ್ ಪ್ರಮೋಷನ್ ಆದ್ರೆ ಬಂದು ಜನರಲ್ಗೆ ಹೇಳ್ಬಿಟ್ಟು ಹೋಯ್ತೀನಿ ನಾನು ಸರ್ ಅವ್ನ ಇಲ್ಲ ಕೊಡಿ ಬ್ರಾಂಚ್ಗೆ ಹಾಕಿ ಅಂತ
ఉంచుకోండి.
ಯಾವ್ದೋ ಚೇರ್ ಸರಿ ರೈ KVR ನಿಮ್ ಕೋಟಲ್ಲಿ ಬಿಟ್ರೆ ನಮ್ ಹಂಗ್ ಮಾಡಲ್ವಲ್ಲ ಹೊಸ ಹೊಸ ಐಟಮ್ ಹೊಸ ಹೊಸ ಅರ್ಥ ಆಗಿಲ್ಲ ಅವ್ರಿಗೆ. ಆಯ್ತು ಕಣ ಮಾಡ್ತೀನಿ ಬಿಡ, ನೀನ್ ಏನು ಹೇಳ್ಬೇಡ ಬಿಡ, ನೀನ್ ಏನೇ ಹೇಳಿದ್ರು ವರ್ಕೌಟ್ ಆಗಲ್ಲ ಕಂದ್ಬಿಡು.
ನಂಬಲ್ಲ